consistent with the Auburn zoning bylaw, which also, and your application recommends some kind of memorandum. We think we've addressed those issues. I will say that the bylaw provisions that allow for this type of application, 8.2.2, 8.2.3, those two provisions deal with non-conforming uses. 8.3.2 deals with non-conforming structures. So that's how this application is being advanced. And I can address each of those. I know I've submitted that in a memorandum, but the use, because the use is already non-conforming, Auburn contemplates a special permit to change and extend or change and modify the non-conforming use. Because the structure is non-conforming, Auburn contemplates a special permit to change the structure, and that's why we're here under this application. The neighborhood's residential. The use contemplated is residential, adding another unit. The roadway, Rochdale Street, is a public way. It's, the addition of a single bedroom apartment at that site is not going to have any significant impact on traffic on Rochdale Street. It's a one-bedroom apartment. It won't have significant impact on municipal services. It won't impact the schools, because again, it's, as I said, it's a one-bedroom apartment. Across the street is the lake, so there's no neighbors across the street. We don't contemplate any nuisance or noise or, the addition of an additional bedroom unit. We don't see as creating any nuisance-type situation, which is what the bylaw requires the board to consider. And site distance, one of the criteria that the board is required to consider, is actually going to be improved. Where the garage right now is so close to the street, moving it back will actually improve site distance along the road. The garage right now, being about 8 feet off the street, off the right-of-way, pushing it back to the building setback lines is going to improve that. So we believe that, we hope that under the criteria established by the bylaw, this project seems, it looks, we hope that the board will consider this project to be a relatively benign change in the use and structure of the property. We believe it's going to be more attractive. It's going to be safer. It's certainly going to be safer for the Mahas because they access the building now outside, and they hope to, with these changes, they'll have all internal stairways. It'll be clean. The new building will be up to date. So that's what the purpose of this application is. Massachusetts, as the board knows, and is pretty much in all over the news, we have a serious housing crunch en masse. There's been recent changes in the zoning act dealing with accessory dwelling units. How do we get more units in play? How do we bring more units in? This application is kind of consistent with what the state's already contemplating. That doesn't kick in till the beginning part of next year, but we're looking to add one small unit to this property, and that's what the purpose of the application is. The Mahas are here to identify any questions or answer any questions relative to their construction plans, what they are. We've given you a rendering. I think we've provided plans as to how we think where the house would situate on the property. There's a plot plan from a surveyor showing that everything's going to be within the building envelope of the bylaw. And we're happy to answer any questions the board may have.
Before I turn it over to the board, is there any abutters that would like to speak on this hearing? Hearing none, seeing none. I'll turn it over to you, Vice Chair Maron.
Thank you, Mr. Chairman. Sir, what's the square footage of the property?
Of the property?
Not the property itself, but the lot size.
Of the lot.
The lot.
Of the lot? It's just under 10,000 square feet.
Okay, so 9 and change?
98 and change, 99, just about 99, I saw.
Thank you. I'm going to reserve for the applicant, if I may, Mr. Chairman, because I wanted to just invest a couple of minutes in the history of this property, and with our building commissioner here, if I may. So this is currently a non-conforming use based on a two-family. Is that correct?
Yes, he
Yes, sir. Sorry, Mr. Elliott.
No, not as far as the building department.
Okay, so could you give us a little bit of history on, because my primary, what I'm driving this, it's not a bait question, but what I'm driving this is, at what point did this become a non-conforming use that we were aware of in being a two-family?
I have no idea. That was, had been done by the assessor at a, you know, a reassessment of the dwelling, and if he assesses what he sees, okay? And so that's different than the building department. The building department has no records of any change to a two-family. The last construction was done there in 2015. At that point there, don't know if a certificate of occupancy had maybe not been issued before, but the previous commissioner issued a certificate of occupancy, which I included in the package, clearly identifying this as a single-family home. Had it been two-family, it would have had to go through a special permit, it would have had to have been recorded on their deed. There's no such record on the deed. So as far as it's established from the building department, this is a single-family home.
Okay, so no such variance has been issued, no such special permit's been issued to flip it to a two-family? Okay, so your estimate is that the assessor may have gone and just assessed what he saw?
Which has happened.
Okay, understood.
Yep.
Yeah, not trying to point fingers at, but just wondering when it became categorized as the current use, and then thereby determined it non-conforming. Okay. All right, thank you very much. Ms. Chairman, I'm going to reserve at this point. Any further questions?
Somebody having a side conversation in the back hallway over here? Can you just check that?
We're picking up a little bit of extra conversation we're trying to clear up here for some reason, so if you could just bear with me for a second.
I can just address one quick point on that. I just spoke to Mr. Maha. They got this property back in the 80s, and it was a two-family at the time they acquired the property. So it's, as far as we know, it's been two-family, you know, at least since the 80s, or two units since that time. They didn't make it a two-family. They bought it as a two-family.
Yeah, I just have one question for, so it's not even 10,000 square feet. In order to have a two-family, you need 19,000 square feet. So that's non-conforming, so the building and the lot.
Oh, yeah, that's kind of what I opened up. That's the irony of zoning, is that privileged non-conforming can be expanded with special permit as opposed to variance requirements. It's one of those things, the worse it is, the more I can do to it. You know, if I have a pre-existing lot that's 5,000 square feet and 50 feet of frontage, I can put a house on it, even if the zoning requires more. But if I have a 10,000 square foot lot with a house already on it, I can't expand. I fall under new zoning. So vacant lots get privileged because they're grandfathered. These, non-conforming uses get a privilege. We used to use the word grandfathering. That's, they don't like that word anymore, but I like to use the word privileged non-conforming. This would be a privileged non-conforming, and that opens up Section 6 of the statute and opens up the bylaw for expansions under special permit, where if this were vacant, I'd need to get a variance. Couldn't do it without a variance, but because it exists already, the special permit process is open. I've had conversations with different town council, and it's ironic that the non-conforming structures and uses get a easier pass than otherwise. So that's why we're here.
I'm good for now, Bob. Thank you.
Ms. Roach?
Sure, so through the chair, we have a copy of an occupancy permit from back in 2015 where the town does designate the property on this certificate as a single family. It does appear there was some work done at that point. Can you or the applicant just speak to what was done in 2015 that there was obviously permits pulled, so it was done legitimately, but what kind of work was done in 2015?
They updated the downstairs.
I gotta have you go to the microphone, sir, so they can record it. Thank you.
They updated the downstairs first floor apartment, is what they did with that building permit. I know it may say that single, I know that's what the zone is.
Yeah.
So the zone is single family, that's why the fact that there's a two-family is non-conforming. I don't believe it wasn't a one-family then. That was an application for that unit, but the use has been identified two-family for decades. So Mr. Ryan, Mr. Maha, Ryan Maha, says he moved in 2002, and when he moved in, there was a tenant above him on the second floor unit. And that's over 20 years. It consisted with what Neil Maha said when he got it with his parents back in the 80s. It was 2 units.
And it's being taxed as a two-family, they're paying taxes to the town of Auburn as a two-family.
Yes.
And have since Mr. and Mrs. Maha bought it in the 80s.
I can't tell you the dates, but Mr. Ryan, Ryan Maha has been paying as a two-family all along.
I am good for now.
Polo.
Thank you, Mr. Chairman. I have some questions on that non-conforming use, and I'd like to reserve comment for after everybody has spoken. You have stated that, to your knowledge, now let me ask it as a question. What, to your knowledge, is the non-conforming use?
Two-family. I think that the zoning bylaw allows for single families. Two families not authorized as a right, so,
If the town and any other appraiser never knew it was a two-family, and yet a special permit was issued for a non-conforming use, that doesn't make sense.
well, the town has this as a two, certainly the taxing is a two-family. It is a two-family, practically speaking, it is. It's been that way for at least 40 years that we know, since they acquired it back in the 80s. And it's
The
a,
fact that this dwelling currently doesn't meet the proper setbacks, that is not, you're not considering that to be the non-conforming use? Especially since nobody knew
Okay.
about the
So-
other, what you're saying was a
So-
non-conforming use.
so I point out that at the beginning that there's really 3 special permits. There's 2 that deal with non-conforming use, and there's 1 that deals with a non-conforming structure. So the fact that it doesn't meet the setbacks now, the structure is non-conforming. All right, so that's a different provision, that's 8.3.2, not 8.2.2, 8.2.3. 8.2 deals with non-conforming uses. That's the two-family to 3-family. Non-conforming structure is 8.3, and that's dealing with the existing portion of the building that is in the setback. So that's why we have I'd say a split special permit. One's for use and one's for structure. Structure's following under 8.3. So the fact that we are too close to the street would require us to expand that structure in the lot. And the bylaw says that you can expand, modify a non-conforming structure, provided that the alteration is within the setback requirements. So because all of this alteration is going to be in the setback requirement, in the building envelope, the bylaw authorizes a special permit to modify a structure, a non-conforming structure. But our addition must meet setback, and that's what the plan shows.
I still have the problem with the two-family use, that, yes, you're saying it's non-conforming now. I guess because I've heard the word used so much on TV lately, I'm saying it was non-conforming, but it's an illegal two-family.
See, I don't know that it's illegal, so that's a great point. So it would be our position that it is non-conforming, but the use predated the bylaw. The use predates the bylaw.
What are those dates, if you're saying that?
Well, the building's been there for 100 years. So and it's certainly we know that it's a two-family for the last 40 years. And I don't know when it was converted, but I know it was converted sometime prior to the 80s. It could have been converted, and I doubt, my experience has been that you can't even get records from towns to show when that use was converted. It could have been converted in the 50s, it could have been converted with a building permit in the 60s or 70s.
That's a problem.
Well, if it's converted, so enforcement relative to a structure under zoning is 10 years. So we know it's over 10 years. So that's why we're suggesting to the board that the two-family component of this property is privileged. I don't want to say grandfather because they don't use that word anymore, but it is a privileged, non-conforming prior use, and we're seeking to change that privilege to admittedly, it's a new use, now we're making it a three-family, and that would be a separate category under the Auburn zoning bylaw. And that's not authorized, but that's why you can change it under the special permit procedures.
I'd like to hold some questions for later. Thank you.
Yes, please.
What he's talking about is that if you have a residence that is being used as a two-family, and you can guarantee, you can show use of this for 10 years or greater, it alleviates them, it denies the town any ability to enforce any zoning infractions against them. And that's all it does. It does not guarantee the use. It does not establish the use. It only says I can't enforce any zoning violations against it. Again, in 2015, it was determined by the previous commissioner that this, at that point, was established as a single family, and I think from that point, that going forward, that is the date we go forward with any changes or anything on this house, because that's an established document.
Just to be clear, though, you said 2015 was established as a single family or a two-family?
Single family. I included that in the package.
No, right, I understand that, but I'm just making sure that we all heard the same thing, because in 2015, they're establishing it as a single family. That means the assessor had to at least view the home, correct?
I would think, Mr. Chairman, as just mentioned, that would negate the privilege of 10 years.
Correct. And if you remember, recently, we had another applicant a couple of meetings ago that came before the board, and they were recently, it was a similar situation where the town had acknowledged that multifamily was pre-existing beyond 10 years, and it kind of really, establishes it per the law, I suppose. So, Ryan, do you have any questions or concerns, sir? Okay. I think you guys have all covered them to me, like we normally do, so I'll just go back around again. You had some reserve, so.
Thank you, Mr. Chairman. I did want to follow up on, so if this property is converted to a 3 separate unit property, what's your plan for parking?
There's a 2-car garage. So right now, there's a 1-car garage. You're going to increase the parking, so underneath this 1-bedroom apartment, there's going to be a 2-car garage. You can see it on the rendering. And then additional parking on the side, which is where they are now, but it's going to take it out of all the parking is going to be located where the house is, behind, the side of the house. So it's either going to be in the house or on the side of the house, but it's not going to be 7 feet off the road where it is now.
So you're
Much half of
proposing
this is going.
an apartment above a two-car garage, and then on the further right side of that garage, how many parking spaces there?
Probably only need one there.
So you're saying that that three-family is only going to require 3 cars?
That's, you have four, two? There's 3 currently, they're going to add a 4th. So they'll have 2 on the side of the garage and 2 in the garage.
Okay, are you aware that you're required 5?
2 inside and 4 on the side? So, why don't you come up and explain that? He's familiar with his parking, what he's doing now.
Hey, everybody. Right now,
Just introduce yourself, I'm sorry. for the
my name
record,
is
please.
Ryan Maher, I'm the property owner. You're welcome. Right now, there's currently 3 spaces on the outside, plus the one in the garage that's there right now with the single-car garage. We're proposing putting a 2-car garage, which will have 2 spaces on the inside, and then 4 spaces on the outside, the 3 that are currently there, and then 1 to the right of the garage area, or on the, right to the right of the driveway, where the new driveway will be. So it'll be 6.
1 to the right of the garage that you're proposing.
It will be where the driveway is now. Right now, the 3 spaces here go right up to there's a telephone pole, and I'm proposing 1 space to the right of that. So it'll be 4 spaces on the outside, and then the 2-car garage, 2 spaces on the inside. 6 total.
Thank you, sir. Thank you, Mr. Chairman. Thank you, sir.
Oh, you covered? Okay. Mr. Cussy?
Yeah, I just have a question with the, we're in an Aquifer 3 zone.
It's a recharge area, it's a, yes.
So impervious, how much are you going to cover? How much of the,
The impervious provisions don't apply to the recharge area. So it does in certain zones, but in this district, there's no impervious limitations for this. I think I addressed that in my memoranda.
Ms. Roach?
I think I am done as far as questions to the applicant.
Okay. Mr. Chacolo?
I'm all set for now.
I'm covered too as well. So since there's nobody else here that has any questions or concerns from the audience, I'm going to go ahead and make a motion to close the public portion of the hearing.
Mr. Chairman, make a motion to close the public portion.
Do I have a second?
Second.
All in favor?
All right.
Okay, so Vice Chair to you?
I do appreciate my peers walking through the nonconformity of the property. So I think I have a good handle on structure versus lot, which I think the applicant was trying to delineate from. Having viewed the property and having better understood their design now and where they intend to put it, I'll be blunt. I don't see a 3-family in that lot. I don't think that the lot is large enough for it, irrespective of the historical nature of the nonconformity. You've got a barely 10,000 square foot lot, and you want to put 3 units in it and 5 cars. And I welcome my board members' thoughts on it, but I'm challenged to see how this is a single-family house that blew up into a 2-family home, and I think that it's at capacity now, based on the size of that lot. And that's where I stand, Mr. Chairman.
Okay. Mr. Cussy?
I have no questions.
Thank you. Ms. Roach?
So, I have to be honest, when I came in here, I did not love this at all. However, I think it's hard to get away from the square footage. They're not even close, and we've said no for way less than this. However, I have 2 points that I want to make. One, I think Attorney Carizzi is right when he says that changing non-conforming use to another non-conforming use is made as a special permit as a reason. There is a reason that it is not required as a variance. It's a less of a standard. So I think the nature and the intent behind that bylaw is to make it easier to conform, to change a non-conforming to a non-conforming. Otherwise, it would require a variance, and it does not. It does if it's land. So I think that has to be taken into consideration. I also agree that we are in a time where creating extra units for families to stay on the same property is a very hot topic right now in all of Massachusetts. I think that we need to think about the fact that if we allow them to change this, they have to abide by the setbacks, so the new structure would conform with the setbacks. And I agree with Mr. Maron that the lot is small. But in essence, what they're rebuilding is another house that's a two-family structure, which is what they have now, a garage, which is what they have now, albeit a bigger garage, with the ability for someone to live in, as an accessory, essentially. I mean, it's really a two-family with an accessory dwelling. That's not what we're calling it, but that's essentially what it is. I'm not saying that I still love it. I'm just saying this, for me, has gone differently than I thought it was going to. I do think there's some considerations. I think it would get that garage off the road, which I think is good. There isn't any abutters that are opposing it. I think for us, for me personally, that's always a concern. When you have, you know, people that are in the neighborhood who are against it, that's something that we always, you know, try to consider. But I do think we have to consider those things. I think, as the building inspector pointed out, you know, parking absolutely has to be addressed, and what they're saying tonight, frankly, I would, if we were to move forward, I would want a condition that it contain those proper parking spots. We don't want people parking on the road on Rochdale Street, that's a fact. But I do think that it is a topic of discussion, that it's a special permit that they're requesting. I think whether or not we think that the town thinks it's a two, or what, they've been paying as a two-family. As far as I'm concerned, end of discussion. Sorry, that's my thought on, we don't have the records to prove that it wasn't, and it's been taxed as a two-family. So, yeah, I think there's some advantages to the project. I think it's certainly a nicer structure. It does get it off the road, it gets rid of the setbacks. I don't like setting a precedent for a lot this small. But in a lot of cases, coming and asking for things that are about lot size would be requesting a variance and not a special permit. So those would be taken, you know, individually. That's it for me, for now.
Mr. DiColo, sir, to you.
One more question for the petitioner.
We'd have to reopen.
No, yeah, what,
You,
we
We're
closed.
closed.
oh,
We have to
thank you.
speak among ourselves.
Would Mr. Chacolo like us to reopen for?
Yes.
Mr. Chairman, I'll make a motion that we open public portion of the hearing for a question.
Do I have a second?
I'll second.
All in favor?
Aye.
Aye. Any opposed? No, okay.
Question for you, and thank you to my board members. The front portion of the garage is, as it exists now, is going.
Correct.
The back portion of the garage, will your current house be connected to that portion, to that garage?
So the garage is coming down. The whole, the current garage, that the whole section of the structure is coming down, being pushed back and rebuilt. So it's that, what's there now on the right side of the house, facing the house from the street, what's on the right side of the house where the garage is, the back portion of the structure, that's being raised, demolished, pushed back, and then reconstructed.
Will there be a connection from the existing home to,
Can you approach the microphone, please, sir?
Let him finish.
Could you approach the microphone, please, sir? Could you answer that question?
Hello, this is Ryan Maher again. Yes, as it sits now, there's a small hallway from the garage that leads into my basement, and we will make a connecting hallway from the new garage to the
See
basement area.
that, but I don't
so
know
that
if it's
it's the
just for,
same as it currently
you know,
sits.
drawing purposes.
Did you catch that, sir?
From what I understand then, where you show a connection from the house to what is currently the garage will not exist.
It will. They're going to, when they push it back, they're still going to connect through a hallway to the existing home.
Breezeway or something?
Through a hallway, breezeway, mudroom type of addition, you know, they will connect.
With an exit to outside?
Exits outside. Everything, so all the stairs, right now, some of the units, the second floor is access to the outside. All that stuff's going to be internal, but yes, it's all going to be interconnecting and accessible, so they can get from the garage to the primary residence, you know, the existing building, and they'll be able to access their standalone new accessory unit. Correct.
Okay. Thank you very much, and I thank my board members for allowing me to clear that up.
Absolutely. Do I have a motion to close the public portion of the hearing?
Before we close, can I just ask a question? I'm sorry.
Sure, that's okay, go ahead.
Mr. Chairman?
Hold on, one thing at a time.
I just would like the applicant, what's the current living situation? Who's living where in this building?
Hello, I live on the first floor. I'm the owner, Ryan, and right now my parents live on the second floor, in the second floor apartment.
Sure, that's okay.
If a special permit is issued, could you just comment, typically a special permit is issued to the owner only, and if the Mahas or Ryan was to sell this property, any new owner would have to come before us and ask for the special permit to be renewed?
So some towns have bylaws dealing with in-law apartments or accessory apartments, and they have that requirement in there. I will tell you, under the new zoning act, the new language of the ADU, they're saying those kind of restrictions are no longer enforceable. So even if they were, that wouldn't be enforceable. The zoning act, Chapter 40A, does allow a town to generally restrict special permits to individuals rather than run with the land, okay? So I'm gonna make a distinction between a special permit that's granted to an owner versus a special permit that's granted to a lot. So typically, special permits would run with the land, especially for construction. In certain towns, under the historic zoning act, accessory units, in-law apartments, that type of stuff would be family-oriented. They had to be family required, and if there was a change of ownership, people had to come back to the board to get them renewed. I will say that under the new law that's kicking in shortly, those type of restrictions are no longer enforceable. That's what I read on the Attorney General's regulations of the new ADU law. Thank you.
Anything else? Okay. No? Hearing none, seeing none? All right, last call. Do I have a motion to close the public portion of the hearing?
Mr. Chairman, motion to close the public portion of the hearing.
Do I have a second?
Second.
All in favor?
Aye.
Okay. Anything else from the board?
Mr. Chairman, Mr. Chicola brings up an interesting topic that I'd like us to explore a bit. This third unit is connected to the home. So I need clarity at this point on if this is a three-family proposal or if this is an accessory apartment proposal. And if it's an accessory apartment proposal, then this puts it into a different light with square footage.
Under the new statute?
I'm not
I'm not
talking-
opening the vote.
I'm not
public portion of the
talking,
hearing.
yeah, with respect,
That's over.
with respect, Mr. Chairman, I'm not talking to the applicant. I was
Sure, no,
actually
I
looking at the
understand.
building commissioner.
Okay.
700 square foot.
As far as that making it,
So we now, we've got clarity now that that structure is going to be, that new unit, we've got 2 units there now. Now we're adding a 3rd unit. That 3rd unit's going to be connected to the single-family home. Does that not make it an accessory apartment?
you know, once you cross over, considering it's a two-family, and then adding another unit, these are just 3 separate apartments.
Okay.
We go into, from the IRC to the IBC, so now we're in commercial, and, you know, those kind of rules and regulations sort of change. Which is, you know, the difference here. Now, you know, the two-family may not have been established and is being used as that, but that does not mean going forward that in any way, shape, or form, when this is done, that the unit proposed is a little over 1,000 square feet. That triggers full HERS for entire construction, fire separation, sprinklers. You know, it just sends it into, you know, just a whole nother, you know, place.
Right, and that was my intent, to ask the question. So I think, Ms. Chairman, before us, respectfully, there are 2 ways to view this, and I think we need to decide which. Is this, in fact, an application for a 3-family? Or do we view this 9 years from the last building permit established as a single-family? Do we acknowledge that it's a single-family and view this as an accessory apartment application to the single-family?
I think that's, I think
And
we're
that-
getting overly.
I don't think so, Mr., with
Well,
respect, Mr.
let me
Chairman, I don't think
explain
so.
my point of view. I haven't even really had a chance to speak yet. So what we have here is a lot that would probably very likely not even be buildable considered today, or slightly buildable. It might have a tiny home on it, maybe a 1,000 square foot ranch. It certainly wouldn't have this home on it today. Nobody would allow that to happen. So this happened at some point in the past when zoning laws were either different or they were just lightheartedly overlooked, however it happened in the past, whatever it might have been. So we have that part of it. And then at some point, in the last 40 years, somebody put an accessory use apartment or split it into a 2-family. And we've had numerous of those issues over time in town occur to that. Even though we don't have anybody, or we don't have any concerns with sort of setting a precedent, because that, we know each application is individual. This is one of those situations where we have a lack of proper documentation going back historically on this property. We can establish a timeline moving forward if we grant it, which means everything is now up to snuff, it's construction, it's code, all of those types of things. It's pretty much done at this point. Nothing else can really happen to this property. And I think that this takes one of those problem scenarios off of the table that we've existed in town for a long time, that they just get overlooked. You know, people don't know what to do with them, and eventually they become a thing of the past, and here we are again. You know, we've experienced that also. So for what that's worth, that's kind of how I see it. I do see the advantage of Ms. Roach brought up that, you know, we are putting the structure within all of the setbacks, which is a bonus. I think that's a safety issue. I like the idea of the additional off-street parking, to be honest. I don't like the additional of the 3rd apartment. I admit that as well. But again, we're going back to the point where we need housing. And this almost seems like a perfect opportunity to correct the situation by adding 1 apartment in, even though it's putting a finger in a leaky dike. I understand that, but I mean, every step forward is a step forward. So that's just how I see it. But-
Well, Mr. Chairman, as always, it's worth a lot, that you would mention for what it's worth. I mean, your comments are always worth a lot. And I don't disagree. I think historically, I don't think the argument is this is an operating 2-family. But I would suggest that the board needs to decide whether or not we treat this as a 2-family or treat this as a single-family with an accessory apartment, based on the design of this.
My question is, in 15, why did they deem it a single-family home? That's what throws me off. I mean, building inspector was in there, and
Well, that's a legal established document from the building department.
Deemed it a single-family
The
home.
use of that dwelling at that time,
That's within the 10 years.
so. As I,
That throws me
it's
off.
how, like, now, like, the assessor can go in and assess what he sees.
These are,
Because the building department has to establish as to what it is.
Well, can I just, and again, I understand, and I just want to clarify something here too, is I can tell you that when I had the assessor in my neighborhood the last time they came through, which would have been the 2015-ish timeframe, he asked me what was in my house, and I showed him. And then he asked me if the other houses on the street were the same, and I told him yes, and some were, varying degrees. They both had 2 fireplaces, they both had a downstairs basement, and he said, okay, and moved on to the next street. So he wouldn't physically look at every single house on the street. He saw that the design was the same, he saw that the structure was the same, it was built by the same company. He looked at my house and went, okay, that's probably what everything on the street has, and he moved on. It's quite possible that he looked at the outside of this house and said, that's a single-family home, as he drove by and doing the assessment. They don't always go in every single home, is all I'm saying,
That wouldn't be how the single family was established. When the commissioner established that, that was during a renovation. And there was a building permit. He went in and did the final inspection on that, the evaluation of that, and issued it actually as a single family.
Right.
So that isn't like the assessor. The assessor can come in and look at it, well, I've seen this, oh, you're using that, you have people living there.
Understood.
And he
Okay.
says,
Yeah.
I'm gonna start assessing, and it says two-family, you're using it. He's assessing for what it's being used at.
Yeah, I see your point.
It does not establish legally what it is.
Okay. Yeah, point taken. Any other further discussion? I mean, what are the concerns of the board? I think the 3-family is the issue, personally to me. I think that the design and the construction is advantageous. I do like it. I think it would be an improvement to the scenario. But again, I think Vice Chair Marion makes a good point. It depends on how we slice it.
Just for food thought, if it's, if it was established as what it is, a single family, and this is an accessory dwelling, it might behoove even the applicant to be interested in doing that due to the very excessive cost that's going to be involved in trying to renovate this to a 3-family.
Okay.
And if both family members are living in the main house, they still have their rental unit. So it does not deny them anything in that aspect, but I feel, getting through here is going to be only part of their hurdle to get a 3-family on that lot.
Sure. Okay. I mean, right, I mean, they're gonna have to go to planning for site plan approval after this, correct? Regardless, so this is, like he mentioned, would be one step in the process if we wanted to consider moving it forward. I mean, we can certainly offer up, as we've done in the past, is a modification or a continuance for a different approach. We've done those things in the past as well, so.
Yeah, Mr. Chairman, I'll just end with, I don't have angst on the fact that it's an operating 2-family. I just don't think that expanding it to a 3-family on the sides of that lot is measurable.
Okay.
I do think that a lot of very thoughtful, humble points have been raised based on housing, based on the nature of folks coming forward with a family, trying to coexist in the same homestead. And I think those are all admirable points. But this is a small lot. And trying to do more with what's there, I think that it's a stretch to do a 2-family in that lot size, respectfully. And irrespective of, and that's why I asked about the parking situation, but irrespective of how they add 5 car heads to that lot, I'm challenged to see that congestion on that road. Because that house, irrespective of setbacks today and then tomorrow when it's built, it's right on the road. Right on the road. So respectfully, Mr. Chairman, I don't think that it fits that lot.
Okay.
And I wish to, I'll just personalize it. I wish the lot was bigger for them. I really wish the lot was bigger for them and they had more room to work with. And I don't hold them in contempt of having an existing two-family there and wanting to expand. That's not my hinge pin. My hinge pin is size and volume capacity in that lot. I wish it was bigger for them.
Okay. Well said, thank you. Mr. Cussy? I'm good. Okay. Ms. Roach?
I'm good.
So I think we've all expressed our concerns. Do I have a motion for the 6 o'clock PM applicant Ryan Maha is requesting a special permit under section 8.2.2 and 8.2.3 of the Auburn zoning bylaw to change a non-conforming use to another non-conforming use, specifically an existing two-family into a three-family residence located at 21 Rochdale Street, Auburn, Mass. 01501, map 17, parcel 203. Is there a motion on that?
Mr. Chairman, respectfully, I make a motion to deny.
Okay, I have a motion to deny from the vice chair. Do I have a second?
Second.
Okay, we'll do a roll call vote for this one. So Vice Chair Maron,
Deny.
Mr. Cussy,
Deny.
Ms. Roach,
I would approve.
okay, and Mr. Chacolo,
Deny.
okay, and I would vote to approve, to be honest with you, but we don't win, so. Do I have a motion open the public portion of the hearing? I think, 'cause I have to address, I want to
Oh,
address that.
motion to reopen, Mr. Chairman.
All right, do I have a second?
I'll
Second.
second.
Favor?
Aye.
Okay. So I did not pass, I apologize, so good luck. I'm sure you could be in contact with the Department of Inspectional Services to see if you have any other recourse of action. Okay, thank you very much. All right, we're going to give them a minute to clear out.
Thank you. Good night.
And then we'll get into our 6:05. Do I have a motion to close the 6 o'clock PM hearing?
Mr. Chairman, motion to close?
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Hearing none, seeing none. Okay.
I know that, but. Oh.
It stinks.
Okay, folks, we're going to move on to the next hearing. If we get you to settle down, please. Our next hearing is a 6:05 PM. Applicant Blackstone Development Group LLC is requesting a special permit under section 3.2.2.1 of the Auburn zoning bylaw for a two-family residence located at 93 Rockland Road, Auburn, Mass. 01501, map 11, parcel 94. Do I have a motion to open the hearing?
Mr. Chairman, motion to open the hearing?
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? Hearing none, seeing none. Good evening, sir. If you could just introduce yourself and go over your proposal, please.
Good evening, Mr. Chairman, and to the members of the board. For the record, my name is Adam Baldarelli for Fletcher Tilton, appearing on behalf of the applicant, Blackstone Development Group. Submitted for the board's consideration this evening is a special permit application to construct a two-family detached dwelling at the address of 93 Rockland Road. And as the board can see from the first slide here, this is what the proposed structure would look like when completed at that address of 93 Rockland. Just briefly, the project summary. As I mentioned, this is a request for a special permit. It is located in the residential zoning district, the RA, Residence A district, as well as the Aquifer and Watershed Protection District of Zone 2. And the lot size at 93 Rockland is a little over 3/4 of an acre, .7712, or 33,594 square feet. Just wanted to give the board some images of what the existing property looks like as it sits currently. It's currently a single-family residence. There is a detached garage. You can see from the photograph on the right side there, the brownish red structure. That's the garage that goes with 93 Rockland. The garage to the right of it goes to the property of 95 Rockland. So this is a single-family residence. It's currently 1,100 square feet. It's currently 2 beds and 1 bath. And as you can see from the photographs here with the layout, the driveway, the property, as well as the detached garage is very close to the property line at 95 Rockland, so it's really very close there. This is the site plan as it currently exists, and this is just another way to see how that property, the driveway, the detached garage, as well as that single-family home, is very close to 95 Rockland. It's on the rightmost side of that property. So what the applicant is proposing, and what we're here tonight for, is to tear down that existing single-family property, tear down the existing detached garage, and construct a two-family detached dwelling. As you can see from the image here, we're proposing to really center that on the front of that lot, front and side of that lot. On the previous slide, you saw how close it was to the other property. It was around 13 feet from the side edge of 95 Rockland. This proposal is to expand that and make it around 30, or exactly 30 feet from that property line on both sides of the residence, but also 40 feet back from the front of Rockland Road. So you can see that it's less crowded, that the property would sit more centered on the lot than it currently is. I'd also like to bring to the board's attention that from a dimensional perspective, the project does meet all the requirements. It has the necessary frontage. As it currently, where it's located, it's required to have 100 feet of frontage. This project, or this property, has 120 feet. The setback is required to be 20 feet. As I mentioned, it would be in this project 40 feet. And the side setback is required to be 10 feet, and we're proposing, as you can see here, 30 feet on both sides of that property. Just another image here of the front, rear, and left side of the two-family detached dwelling as constructed. You can see separate entrances for both units, as well as that two-car garage in the front of that property. I wanted to show the board the first and second floor plan. So here's the first floor of that property. You can see that's kind of an open layout, that there is, again, that two-car garage. There's a fireplace. It's planned to be an electric fireplace. There's that half bath on the first floor. And then with the second floor, there's the 3 bedrooms, 2 full baths on the second floor, a in-unit washer-dryer, and I can mention for the board that each unit is going to be approximately 1,600 square feet. So as part of this new construction, each unit would be approximately 1,600 square feet with all new amenities. The applicant here really wants to make this a sustainable property, prepared to have it be 100% electric and to exceed LEED standards. As I've mentioned in the memorandum that I submitted or filed for the board's consideration, I do believe that this meets all of the threshold requirements for a special permit. I'm happy to go through each of the 9 considerations, but I believe I wrote it better than I can say it here tonight. So I'll leave it at that unless the board or members of the community have any questions for me about that.
Thank you. Do we have any abutters that would like to comment or have any concerns on this particular application? Hearing none, seeing none, I'm going to turn it over to the board. To you, Vice Chair Maron.
Thank you, Mr. Chairman. I was hoping that we might have an abutter or two to join us for this one. I did have an opportunity to view the lot, and so everything on the lot existing, including trees, all that's coming down?
The so the residence is coming down, the detached garage would be coming down, the driveway on the right side would have to be, would be changed, and I believe to make way for this property, he would have to do some minimal vegetation removal. I believe there have to be a tree removed in the center of the property so that this residence could be more centered.
33.9 for square feet for the entire lot, right?
That's correct.
And you're going to be on town sewer and water?
It would be town sewer, yes, and water, yes.
I'm going to reserve, Mr. Chairman. Thank you, sir.
Thank you. Mr. Cussy?
I have no questions, thank you.
Ms. Roach?
No, I don't either. It's a really nice design, honestly, and the lot, since that seems to be a hot topic today, the lot is obviously big enough. So I don't have any other questions for now.
Okay. Mr. Chacolo, to you, sir?
Thank you, Mr. Chairman. The current garage is being torn down also.
Correct?
When the new structure is put up, how close will you be to that lot line?
Is that what? I'm sorry?
To that lot line, how close will you be?
So it's going to be 40 feet from the roadway setback, and then 30 feet from the side, the left and right side.
Can't read
I
it.
know,
was
it's
too
so small, yeah.
It was so small I couldn't read it.
Okay.
So the existing driveway is going, obviously.
Correct.
Okay. That's all for now, Mr. Chairman.
Thank you.
I'm all set.
Thank you. I have no questions or concerns. Anybody else? Okay.
Mr. Chairman, if I may, just one follow-up. There's no relief necessary for any setback dimensions, correct?
Correct. We believe we're in compliance with all dimensional requirements.
I'm sorry, of course. I obviously do have one, sorry, through the chair.
That's okay.
And I'm sorry if this was in your brief and I missed it, but is the intention to keep this as a two-family and rent it, or is this going to be condominiumized and sold each unit, each side?
After further conversation with the applicant, we do believe that this would be condominiumized and sold individually.
Okay, no questions from me.
How the hell
Anyone else?
so small?
Again, just want to make sure no abutters came. Okay, hearing none, seeing none. Do I have a motion to close the public portion of the hearing?
Mr. Chairman, motion to close the public portion of the hearing.
Do I have a second?
I'll second.
All in favor?
Aye.
Any comments, concerns?
With the risk of being cheeky, Mr. Chairman, I wish we could borrow a little bit of lot size from this for the previous applicant.
Yeah.
Respectfully, but truly, but I did have an opportunity to view the property. Like Ms. Roach had mentioned, I mean, I think it's a really smart design, it's beautiful duplexes, and I think it'll well suit that lot, quite frankly.
Okay. So if I have no other concerns, questions, or comments, do I have a motion on the 6:05 PM applicant Blackstone Development Group LLC requesting a special permit under section 3.2.2.1 of the Auburn zoning bylaw for a two-family residence located at 93 Rockland Road, Auburn, Mass. 01501, map 11, parcel 94?
Mr. Chairman, I'll make a motion to approve with standard conditions.
Do I have a second?
Second.
All in favor? Aye. Any opposed? Hearing none, seeing none. All set. Good luck, congratulations. You can contact the Department of Inspectional Services, and they can proceed with the paperwork for you.
Thank you, Mr. Chairman. Thank you to the members of the board.
Have a great evening. Do I have a motion to close at 6:05?
Motion to close, Mr. Chairman?
Do I have a second?
Second.
All in favor?
Aye.
Aye, okay. So as soon as they can clear out, we'll move on to the 6:10. Here they are. Okay, so that was easy. There wasn't a lot to change around. Okay. So the 6:10 PM applicant, Arbor Recycling Incorporated, requesting a special permit under section 8.2.2 of the Auburn zoning bylaw for a warehouse located at 47 and 49 Rockland Road, Auburn, Mass., map 17, parcel 177 and 224. And I just want to remind the board, this was in discussion for a while. They had previously come before the board, we had voted on it, made a decision. They asked that we suspend signing and approving the final steps in that decision, because apparently there was some communication between the applicant and the abutters. So I just want to bring everybody up to speed on where we were on that particular.
Mr. Chairman, if I might interject, we never approved,
Correct.
okay? We held it, I would say, in abeyance. We were asked not to sign
Correct.
or record.
Correct.
Okay, the motion as it's written here, if we act on this motion is wrong. Okay? Because
Okay.
we're acting on a motion, okay, which was previously acted on, okay, and it came in favor of the warehouse, I'll say, okay? This is not the wording that we approved when I gave my reasons for denying. Excuse me. This is not, what we're doing here is not, we're not going to be voting on any special permit here. This was a discussion between the two parties,
Correct.
admirable, okay, and essentially, the two parties, I believe, have come to an agreement where this motion is not necessary. Nobody is winning, nobody is losing.
Well, I'd like to find out what's going on from them.
Perfectly fine, but as long as we're just discussing and not discussing for the purpose of voting on this motion here at 6:10 PM.
Mr. Chairman, if I may, from a procedural perspective, I think what Mr. Chacolo may be implying to some degree is that this is written as a hearing. Now, there has been no motion to open this hearing as such as a hearing. I am equally curious to get to this and find out what has been discussed, and I applaud the parties for even taking on that process. But from a procedural perspective, I want to make sure that we're correct, as we all do, want to make sure we're correct here. So I would suggest there's no motion to be made to open a hearing. This is an agenda topic, we're in discussion. But I think where Mr. Chacolo is leading is that we don't want to necessarily open a hearing in proposal of voting on something. Does that make any sense?
It does, but I think we're splitting hairs because we haven't even heard from the applicant yet on what they're proposing.
Right.
But if we were to do this, it would be, since we have not signed that decision, it would be procedurally, would we step through rescinding that decision, reopening that hearing, and moving forward? So there would be 3 or 4 steps in order to do that.
Mr.
But-
Chairman, I would think you would just have to vacate what's been previously done.
And that's certainly a possibility. I think that the
And
board
then,
can discuss that.
this is now a discussion that could have taken place on the steps outside.
Yeah, so, Mr. Chairman, if I may, let me put my word salad aside for a minute. How do we get to talk to the applicant without opening a hearing on this, is my question.
I'm going to move over to him and let him talk.
We're not going to open a hearing.
So, I don't see the, I kind of feel like we're splitting hairs here regardless of how we get here. We're a public body, we're having a public discussion, we're opening a hearing that opens a record. That's really all we're doing. We're opening a hearing to open a record.
Okay.
Agreed.
And then that follows the procedure of recording that particular hearing. And then if we have to step through and change any procedurals, or past actions during that, we can do so during that hearing.
Got it.
But I don't think we can do so until we open a hearing.
I'm in agreement.
Okay.
Mr. Chairman, make motion, open the hearing, please.
Second.
Do I have a second? All in favor?
Aye.
Aye, okay. So with that being said, we have an applicant present that would like to give us a briefing and bring us up to date on where we are in this pile of spaghetti we have here.
Sure.
So, go ahead.
Thank you, Mr. Chairman. Todd Broder from Fletcher Tilton here on behalf of Arbor Recycling. So yes, a little complicated in terms of how we got here, where we're going, et cetera, but I think maybe after we talk, I think I'd like the neighbors to talk to you as well, then we can decide what we need to do. But, you may decide that we have nothing to decide, so we're just discussing where we might go. So there were conversations. I personally was not present at the meetings. The applicants and operators of the site met with a couple of the neighborhood representatives, Gary, and I think Adam was there as well. And, a number of good discussion items, things that we might not have known were concerns came up, and things that are able to be addressed. I think now there's a feeling of a good working relationship. So, we have some suggestions, and I certainly think it's important for you to hear from the neighbors too, just to, kind of confirm the conversations. But, we think operationally we can do some things to limit the impact on the neighbors. And so we would be, willing to look at conditions of an approval should you decide to go back through that process. And, I think there are some things that we're trying to do to move forward once we get past this process. We need bathrooms in the facility, the roof needs some work, the drainage needs some work. So we have more steps to go, I guess, once we get through this. We have, right now we have not really great working facilities for the people that are in there. We have an employee who's coming back off maternity leave, who we'd really love to get a proper bathroom for her when she returns, which would be a great step forward. But in terms of, things that we would agree to as the applicant, hours of operation for truck deliveries, and they break down actually into two separate issues, and I just wanted to spend a second to talk about that. So there are company trucks that clearly, we control the drivers, we control the trucks, their routes, and times that they, go off into the world and then come back. Those trucks are generally operating right now 7 a.m. to 6 p.m., and they kind of close the gate. If anybody comes back after that, there's another site, off-site, that they're heading to, so that there's a little less disruption in that evening hour time. But there are also, and those are company-controlled trucks, there are also redemption facility vehicles that come to our site, redemption centers. I've learned a little bit about this now in my time talking with Kevin and the applicant. These redemption centers, as they've been historically called, they're required actually to bring their stuff to the site. So those are outside people bringing their stuff to us, and those are coming. At this point, we'd like to limit those because we think that would stretch out during the course of the day when they come to the site. So they make appointments to come to the site. So right now, they like to come in the morning, in the early morning in particular, and that's a little disruptive. So the thought is to maybe have those contractors be coming in between 9 a.m. and 5 p.m., sort of, midday kind of working hours. It stretches out, and then we can do it by appointment, so we can control it even a little more. We don't want multiple people in there. It just clogs everything up. So there's some logistical work that goes into that, but the applicant's perfectly willing to do that. And I think we'll limit the noise at 7 a.m. The disruptive, type of noise at 7 a.m. will be much more limited. So hours of operation in terms of truck deliveries and exits to the site is a big topic. One of the other things that we discovered was operationally there are glass bottles that are recycled at a facility such as this, and on occasion it seems that those containers are being emptied into each other outside of the facility, the building itself. When done inside, it's much less disruptive than when it's outside. So condition might be that all the emptying of crushed glass containers should occur inside the facility only. So just another, item to kind of offer that helps with disruption. And the other is just generally working on truck flow and directional flow, and truck patterns. So one of the issues seems to be that an inexperienced driver was going through some revving on Rockland as he headed up towards Auburn Street, and it was causing all sorts of, stall and, sit there and cause all sorts of problems. It was made known to the operator. They know that particular employee no longer drives that particular truck. He does something else, and it's seeming like it's working better. So that's just something, a good discussion, a little point, but it came out of, the conversation that can be handled and can be helped. So I think, we're working in the right direction there. I think those were the kind of the big ticket items, but I certainly think you should hear from the neighbors. I think their perspective would be great, and obviously you want to hear from them, make sure they're in agreement with what we just talked about, and if there's something else that I missed, I'm sure we're glad to talk about that as well. Oh, Kevin's got a point here. Sure, come on.
Sure, yeah, well, just approach the microphone, please.
My name is Kevin Kelly. I'm the CFO for Arbor Recycling. One of the major things we talked about was to try and reduce truck traffic and to smooth that out so that you don't have everybody coming in from 7 to 9 and then everybody coming in from 4 to 6. We have a way of controlling that, as Todd said, and that some of the trucks, not a lot, about a third of the trucks coming into the facility, we can schedule in the middle of the day. So again, it just smooths the flow out to make it less disruptive, make it seem less like a highway during the course of the day. The other part, the major part behind all of this is for the special use permit is for allow us to start the bailing in full. And we invited the neighbors to come to our facility, who took a tour of the facility and actually watched us doing the bailing, so they could actually see the effect, as I had said in the last meeting, is that every 5 trucks in today is 5 trucks out. If I get 5 trucks in, I get to bail that and reduce that product down to 1 truck. So it's another opportunity with being allowed to get the special use permit to again reduce the volume of trucks that are coming through the facility. So that was just an overall that Todd didn't mention, that is a big part of the conversation. And the same, I will thank Gary and Adam for setting up the meeting and having us sit down with the neighbors to discuss this so that we could work out what they were concerned with and to convince them that, you know, as I told the 2 gentlemen, is that we're neighbors, we live here too. I may sleep someplace else, but this is our property. I'm here all the time. We want to work with our neighbors because we don't want to be fighting with people, so.
Okay, so I'm assuming we probably have some abutters that would like to speak on this, so if anybody would like to approach the microphone, please, give us your name and address and your comments. And also, thank you for all the abutters that have been coming here the last couple of months with this whole issue. Thank you very much for coming in, taking the time out of your busy lives and coming in here and give us some insight on what you're actually looking for, so I appreciate it. So thank you. Go ahead, sir.
Thank you. Good evening. Tim Daly, 25 Rockland Road. We did have a great meeting. Mr. Howard set it up. We came up here, we talked to everybody that they brought. And in the beginning, it was kind of like, you know, we're here complaining, but I think for the 2 hours that we talked, we see a different light. We see them in a different way. Hopefully, they see us in a different way. We got a lot accomplished, and they've made some concessions. We met with them 2 weeks ago, and they invited us up. We went on a tour of the building. We stood outside. We listened to the bailers. One of the neighbors had complained about the glass. That's taken care of. The truck traffic has gotten better, thanks to them. It's you know, it's different. I don't get 6:45, 7 o'clock. I have to hear the truck coming up the street. So it's been great. The tour from Joe was fabulous. So from where we're standing, we would just, and I don't know legally what has to happen, but we would probably like to see, I know they want to get that other baler machine up. If it's as quiet as the one is now, we don't see any problem with it, with them going ahead and doing what they have to do. Our point is just, it's great, I'm grateful that we all got together and we sat down, and no offense to Attorney Broda, but we just wanted to talk, and we did. And we were there, why we were there, they listened to us, we listened to them, and I think it was just a great neighborhood event. I think from our standpoint, we would like to see maybe, and I don't know how you do it, but we would like to say, let them get up and running, see how it is, put everything back 6 months, take another look at it and see how we're doing. I will say that Kevin has called me on my cell phone at home and said, this is what we did this week, how do you like it? Okay, this is what we did last week, how do you like it? So I think that's a huge step that we have now, and I feel that I can call him anytime and say, you know, this happened yesterday, what do you think? And I think we'd be open to good discussion. So I'd like to say thank you. And I don't know what you can do as a board, but that's where I stand.
Nice. Thank you very much.
Dick Chandler, 35 Rockland Road. I totally agree with what Mr. Daly just said. I was at that meeting, and it was fantastic. It's probably the way business should be taken care of overall. It just worked, and it's smooth. I don't hear the trucks anymore. Maybe I'm getting used to them, I don't know. Maybe I'm just getting old, but, well, both. But there's nowhere near the number of trucks. The hours have been rearranged in our favor, I feel. So I don't think, but I would like to let it go through like a 6-month process and see how it works after they're able to get their trucks and their redemption trucks on a certain schedule. If it continues like it is now, then I have no problem with it.
Any other abutters? Yes, ma'am?
Wish they'd all go like that. That was wonderful. Just wonderful.
Hello, Jody Balkus, 41 Rockland Road. I'm 2 houses from their main entrance, and I work from home, so I see trailer trucks all day. And yes, maybe then, they're going to stop them coming out at 7 and they'll come out at 8. But trailer trucks up and down the road all day, regardless of how they do it, is annoying. And does not fit our residential area. We have a business, when we were here a couple of months ago, one of the young ladies that was here made a caveat about how the business should be in harmony. That's part of what they're going for a special permit to, for it to be industrial or whatever, needs to be in harmony with the residential, area. We have a business on Rockland Road up the street. It's a J.S. Mortimer, which is an HVAC. You wouldn't know they're there. They're just, basic trucks. They have like one box truck, but you don't know that they don't disrupt the neighborhood. But this business does. I mean, it's trailer trucks, 18-wheelers, like huge 18-wheelers. They rattle, they bang. They've been doing business right along. Like, they got denied a permit, 2 months ago. Nothing's changed. Yeah, okay, maybe they've, a couple of less trucks coming up, but it does not fit. It's not in harmony with our residents, and I strongly oppose it being there. I mean, I'm just one person, I'm just one house, but I just don't think anything they can do changes the fact that there are 18-wheelers coming up and down the street all day, regardless if they put them into the middle of the day. I work from home, I see them all day long. Big box trucks, whatever. This is a business that belongs down in the industrial complex on Sword Street. I'm sorry, I disagree. So I just wanted to say my piece. Thank you.
Anyone else? Yes, sir?
My name is John Capuano, and I have the property which is right across the creek from the driveway. And this is the first time I've heard about this going on. But is this zoned for business, this property? I wanted to know if it's zoned for business. Is it zoned for manufacturing? Because when you're converting something from one thing to another, that's manufacturing. Okay.
So the use group is, the variance follows the property. It's still full in effect, and so they have a right to use that building for that purpose.
So it's really not a warehouse, it's manufacturing because they're converting.
Right, and that's exactly what it was approved for.
It was. That was way back.
I don't have it with me, with the,
Okay, so they're not going to extend the building. They're not going to build out on the building, right? Okay. So if you go down there, you got this dirt road that goes up to the building.
It may not be for long.
What does that mean?
There's conservation issues going on, they may be required to pave it.
Oh, yeah, okay. Because there's wetlands where that road is.
Slowing all the conservation engineering up is dealing with the wetland issues that they have there.
Right. Well, you listen to the neighbors that I just heard, and they're from 35 and 25 Rockland Road, which is quite a ways away from that driveway. The neighbors that are closer, like possibly me, in the future, well, I don't want to hear trucks going back and forth on that driveway in a manufacturing facility. It's residential all around there. You drive up that little dirt road there, and there's houses that are like, abutting that property. And I don't see anybody here from those houses. Maybe they are, I don't know. But that's manufacturing, and there's going to be noise involved there, and there's going to be trucks involved, and there's going to be backup horns on the trucks all day long, and it's going to be an annoyance. And when you get to 25, you may not hear that because you've got 300, maybe 400 yards of property between the driveway and those houses. But when you're right up on top of it, you're not going to be able to silence that noise. And all the trucks have the bells and the whistles that when you're backing up. And that's very, very annoying. And I just think that this is the wrong place to have many, many trucks going in there all day long, 5 days a week, maybe on weekends, who knows, and promoting a business in a residential area. That's what I say. And I would say no, but that's your job. Thanks.
Yes, ma'am?
Jody Balkus, 41 Rockland Road. I'd also like to make one more comment, because they had said something about, so when those trucks pull out, they have to do a wide turn coming out, the huge 18-wheelers. They do stop traffic, not a lot, but they do, stop the flow. I'll look up sometimes, there'll be 2 or 3 cars sitting there waiting because of tractor trailers pulling out. But they also have to now accelerate, because we're at the bottom of a hill. So they have to now gas it to get up the hill. So now it's even more, it's more exhaust, it's more noise. So it just doesn't work to have 18-wheelers up and down the street. It's not the place for it. So that's it, thank you.
Anyone else? Yes, please, but I'm going to move over to the board very shortly.
I'll go quick, yeah, that's quick. In fairness, we don't like it either, but if we don't negotiate, then we're going to be stuck with whatever happens and happens. So that's why we met, to see if we could better what was there. That was our only reason. I don't think it should be there either, but they own the building, and that's what it is. So that's the only reason that we met. And I guess our point is, we wanted to talk with them, we wanted to see what their thought was, what our thought was, and that's how we got to that point. But, I mean, as far as me just making a decision, do you want the trucks there? Well, no, but if they're going to be there, then why don't we work together and see what we can do? That's where we came from. Okay? Thank you.
Vice Chair Maron, thoughts?
Mr. Chairman, thank you, sir. I applaud the effort. I think that the world could have less wars if people would just get together and talk about things. So, I mean, it's very admirable, quite frankly, to see community and business come together like that. And, yeah, I do have a question for the applicant, if I may.
Sure.
We're still open.
Yeah, we are still open.
So the scheduling changes and the scheduled trucks, so the scheduled by appointment trucks, is that a sustainable practice in the business model, or is that, I mean, is that something that's truly sustainable?
Yeah, I think the only issue that they're having right now, which is difficult, is the trucks that come back after 6 that have to go off-site to another location. Because actually what happens, and this is just after spending some time with Kevin talking about how this all works, if they go to another facility after hours, that truck then comes to the site in the morning. So it's not intended that the trucks would come back at any given hour in the night up to, midnight or something like that. But having a little bit more room on that side of things to come back, they sometimes just get locked up in traffic somewhere or whatever, they don't get back by 6. Again, then they come to the site first thing in the morning because they need to be put into use. Having some flexibility on that side of things to maybe extend that, and it's not meant to be abused, but having some flexibility there, I think that operationally would improve things and actually make things even a little bit better.
Yeah, I mean, I think your examples were a perfect illustration of controllable, uncontrollable. right, with best intentions in mind. And that's why I ask if it's truly sustainable, because there are things you can control. You could set that schedule, but there are things you cannot control: traffic, you cannot control, ebb flow. So I just wonder if even best of intentions, if that's a sustainable practice for the business.
Kevin seems to say yes.
Because for me, respectfully, it lands on such a strong point with the neighbors and such a remarkable improvement that they profess. But what can you really control in that schedule?
The redemption vehicles that come in for deliveries, completely within our control. We can book them, and we shorten the hours to 9 to 5, which eliminates, obviously, early in the morning, where most of them want to come, because everybody kind of knows, truck drivers like to do things early. Well, sorry, redemption deliveries can only be 9 to 5, which again smoothed that out. Our own vehicles, one of the early things we did and continue to do, if a guy does come back late for whatever reason, traffic, breakdown, any story, he does not come onto the property after 6 o'clock. He goes to our truck repair facility in Worcester. So yeah, the answers are we can control, and there is opportunity to further reduce the number of trips on and off of the property, but that is something that we told Mr. Chandler and Mr. Daly when we met with them, that when my dispatcher comes back from maternity leave, we want to get her to try and analyze that if we have a guy coming in, say, at 7, coming back at 7, would it be less offensive to the neighbors if he came in at 7 and came right onto the facility, rather than go off to Worcester, park there? Because then what happens is he comes in the morning at 7 and he's leaving at 8 or 9. So now you're getting 2 truck trips early in the morning, where I could only have 1 if all he's doing is leaving. But we reserve that analysis until hopefully my dispatcher comes back on time from maternity leave, and she can actually do that work for us. So it is completely controllable.
Thank you. Thank you, Mr. Chairman.
And I think we mentioned, but just to highlight again, the baling operation, so it's essentially, crushing cans and bottles, so reducing them from this to this, creates less need for truck trips. So, I think we said in a prior hearing, it's as bad as when we were talking, it was as bad as it was ever gonna be in terms of trucks coming and entering. It will only get better.
Okay, Mr. Cussy?
Yeah. Gary, are you sure that that's industrial use? I thought the variance was for a warehouse. I don't think it was a variance to operate.
The use group that it is approved for is exactly what they are doing in there. We verified that the use group, that category underneath of the product, dismantling and repurposing is exactly part of the operation. And, and as far as the operation goes and the control, that nobody can sit here and agree that should be there. Okay, but that's something that happened long before us with a variance that is something that's upheld, and there's no breaking it. So they have a right to use that building, come and go from that building. The real detriment that's controlled as far as the board for what they can do is the obnoxious noise and things like that, but that is typically the noise coming from the manufacturing within the building. It doesn't really deal with the trucking. The truckings are public, state-registered vehicles. They're on public roadways and things such as that. I mean, this is a bad situation, no matter how you slice it, but it's not something of our doing. So the best we can do is try to make it the best it can be for everybody involved. And that's the way I see it. You guys got a tough job. So I just try to look at what is the best case scenario come out that we can do in here before it goes before one person that just says, well, it's guaranteed and there's no restrictions.
Yeah. The safety issue is huge on that road.
And there's no question, but it's a public, and that's not part of the privy though. That's like, that was established. That was there. I don't know if we have any control. That would be more Adam to deal with if there's any control. But we talked about it. I don't think there is any. And so again, it comes down to how do you best control a bad situation? Because it is, there's just no, there's no perfect winners, you know, the warehousing is compromising because they're trying to work with the neighbors obviously having to compromise because they have something they don't want in their neighborhood.
How many neighbors were there at this meeting?
But the better they talk together and work together and have communication, I think is the best that, you know, you can really try to strive for, at least, you know, the way I see it.
Okay. Ms. Roach?
Yeah, so I do have a couple questions. Attorney Broder, maybe you know the answer to this, but if not, maybe the applicant can speak to. I just want to touch back on the bailing for a second, and I know that was talked about at the other hearing. Can you give us an estimate? If you have 30 trucks now, are you going to have 5? What's the estimate? If the second bailing machine is allowed, is there any estimates on how many trucks? I mean, I grew up on Rockland Road. No one wants trucks. I totally get that. It is a cut-through sometimes from that Auburn Street to get over to Boyd Street to get into Worcester. Rockland Road seems to be a hot topic, by the way. My old neighborhood is thriving. But is there any data on, you know, what could that reduce and what are the number of trucks? What are we talking about here?
So when Kevin and I talked about, you know, the bailing operation and how that helps reduce, it's essentially for 5 trucks and it's 1 truck out. Does that answer your question?
I guess, and how many would you say are coming in daily?
40 trips in and out. Okay. So I don't know if you heard that, but you reduce 8 to 10 trips a day.
So we're in the low 20s daily of a truck. In that same truck, 20 of them come in and 20 of them come out, I assume.
In the 40 count that we gave you?
Oh, I'm sorry. 40 now, and you're reducing it by like 8 to 10, so it would
Yeah,
be in the
so about 30.
low 30 range if we, okay. My math isn't good. And then the other question I do have is, as far as the meeting with the neighbors went, how many neighbors were at the meeting? I think Mr. Cussy brings up a good point. I know everyone was invited, so I'm certainly taking that into consideration as well, but what was the turnout?
So when we last met, you know, there were only a few neighbors here, and those that were present sort of designated the 2 gentlemen that you heard from who spoke about the meeting. The other neighbors that we heard from tonight, not that we ignored them, but they were not part of that conversation. They weren't at the prior hearings, at least to my recollection. But, you know, I think the issue of who was in the room or wasn't in the room, it's really trying to get to what's better for everybody in the whole neighborhood. I don't think we tried to do something that was better for Mr. Daly than there was, you know, and how it impacts everybody else. You know, yes, it can be different. If there are particular concerns, you know, I think we've shown that we are willing and trying to address those. I mean, the I don't like it, this isn't okay, we can't address, right? Because we're there and this is the use, but can we address operational issues that control sound and timing and things like that? Yes. And I think we've shown in good faith that we're willing to do that.
Sure, and I think we as a board know that if this is taken past our board and your client is given permission to do what he does, it will contain no conditions, and they'll be able to do whatever they want. He doesn't seem like the kind of guy that would go back on some of the promises that he has made to the neighbors, but he certainly would be under no legal obligation to do that.
That's correct.
Right, I just want to make sure the neighbors are, I think Mr. Daly and Mr. Chandler are aware of that. But I think part of our job is sometimes we have to approve things that we don't like with conditions to try to make it as happy as we possibly can. So, okay, nothing else from me.
Stuff to go through the planning board, okay, and conditions can be set on this, you know, permanently on the planning board, and that's what we spoke with them as well about. They're the ones that actually can, the lighting, the hours, this, that, and stuff can be actually put in put in place on a, you know, an enforceable level. This is just really about the use of that building.
So we could request a traffic study and a sound study. I think we've seen no traffic studies or no.
That'd be, I don't know if that would be here or that would be the planning board. But yes, that can
Correct.
definitely be,
Yeah, I mean, that would be.
Adam's the one for that question.
So can I just need to recap here for a minute. I want to bring everybody back into the middle of the circle here. But I'm going to get to you in a minute too, Ryan. So, but let me just explain something here. So we have specifically to talk about the fact that this property had a variance attached to it back in the 1960s, okay? That limits our ability, regardless of what the language is in that document. If it says at the favor of this or the favor of that, ultimately, that document wins over no matter what it is in court. This applicant, should they choose to go to court, would very likely be able to continue to operate until that hearing came up, which could be 2 years, 3 years, in fact. We don't know how long that takes. They're here willing to negotiate in good faith to be good neighbors. I think that's kind of important to talk about. As Ms. Roach brought up, something is going in that building because of that paper that was signed in the 1960s at a favor to somebody else. Let's call it what it was. It was probably a building inspector at the time doing somebody in town a favor because it was a buddy. That's just what it is. And unfortunately now, here we are 50 years later, stuck with it, and we own it. So to address Mr. Capuano and Ms. Balkus's concerns, I know that you have said, well, we were just here this evening for the first time and just hearing of this. We've been discussing this for months. If you were in a butter, you were notified duly by the town. Were they on that abutters list?
I have to look.
What about, I'm assuming if they were abutters, they were notified by the town though, correct? Right. So something is going in this building, regardless of whether we all like it or not. I think you need to understand that. These balers that everybody is concerned about, you can go on YouTube and you can see what they are. As somebody who's worked in a manufacturing facility numerous times throughout my life, those balers make almost no noise, literally. All they are is basically a giant piston. It's a trash compactor. And the only noise you're going to hear from those balers is basically the pump motors, right? Because they're run hydraulically. So if you hear a pump motor whining, it's because that piston is being pressed a little hard. But you're not going to hear any noise from that thing. It makes very little to almost no noise. As far as truck traffic is concerned, we have a massive truck traffic problem in this community as a whole. But again, that is not part of our purview. We can discuss whether or not this particular activity is appropriate inside the building on the lot. If we decide to agree to that and move it forward, site plan approval, traffic conditions, all those things get addressed by the planning board. Right? So what we have to discuss in our purview here is the fact that the variance that exists in this particular scenario is best suited what we have in front of us. The reason why we were asked to delay signing or hold off signing it is because the two parties, the applicant and the abutters, did not anticipate us having a vote that first night, from what I understand. And we moved it to a vote before they were complete with their negotiations. So where we are is now is if we would consider rescinding or vacating the other conversations that we had to sign, with the understanding that they have come to a working agreement, and it is likely the best scenario that we will have in this location. Otherwise, if we decide to deny this or it moves on, it could go to court, they can continue to operate 2 or 3 years later, the judge says, yes, that's okay. Or the next scenario is somebody else comes in and they don't take this approach to it, and they're stripping cars in there and stacking tires in the parking lot. So that's kind of how I see this scenario. Again, unfortunately, we are the board that gets to untangle shenanigans from the past, if you will, but here we are. So I think to me, we've reached the best-case scenario with this. If this is not palatable, then we just have to vote to agree to allow it to continue, or we have to vote to deny, and they'll make their next steps, which would likely be filing a lawsuit in Worcester Court. So I think that's pretty much where we are with all these. Bring everybody in the room up to speed on what we understand now. So this is kind of what we have to look at. So I'm going to bring it back to the board now and decide, and let you kind of hash those things out.
My complaint is that, like, right now, we have two abutters that are saying no, and two abutters are saying, we're okay with it.
And the
I
two
mean, there's a
abutters that have
lot
been
of
here for 3 or 4 months versus the two abutters that just showed up.
Yeah, but I mean, they're here, so obviously they weren't involved in a meeting. I mean, how many, I don't know.
Mr. Chairman?
Is the whole neighborhood on board, or is it just two? That's what
Can I address that?
Making it sound like.
I'll be quick. Can I address that, the question?
All right, so we can address this, hold on. We can address this, I'm gonna allow the abutters to speak again, but we've discussed this ad nauseum at this point. We all know what the problems are, we all know that it exists, so we either make a decision or we don't. So I'm gonna allow everybody, all the abutters to speak, and then I'm gonna close the public portion of the hearing after that, because we have other items to talk about, and we have other people here that need to be addressed. If you would like to do a timer, that would be fine.
I'll be quick.
2 minutes.
Go ahead.
Sorry to
2 minutes.
interrupt. I'd just like to say that we've been coming to these meetings since April, okay? I put a note in everyone's mailbox on the street back in the beginning, okay? We've been talking, yes, it's just the three of us that have been coming to the meetings. It's posted. I'm not saying I agree with the decision, but they're there. So I agree. But they're there, so why should we not benefit from them being there, or just having them be there and we have no say as to what goes on, right? At least a decision. My only thing with you folks is, can we reopen this in like 6 months if we're not happy? Or do we have to, what do we do?
If we issue the permits and it goes through the entire process, that's it. There's nothing we can do for you. Also, what I would like to add, as somebody who's worked in a logistical scenario, dispatching and controlling vehicles and trucks, I absolutely respect the fact that they want to try to do the best they can, but that's not going to happen. We know that. I know that. Truck can break down on the highway, traffic jams can happen, accidents happen. There are too many other variables. So I personally, as much as their efforts are applauded, and I recognize the fact that they're going to do everything they can and work with you in the future, it's too unpredictable to be able to say what those trucks are going to do. And if you don't realize that, then I'm sorry, but,
Okay.
you know.
I do realize it, and I just would like to say that I've come to every meeting and I've spoken at every meeting. I know, I'll go quick.
Yeah.
And I think that I've taken into interest on the road. It's not just my house or my neighbor's house or their house. Okay, I've taken interest on the whole road to make it fair. Yes, we've been at the meetings, but I do consider the neighbors as well. Thank you.
Jody Balkus, 41 Rockland Road. First, I want to comment that I have been to prior meetings. I've been to a conservation meeting because I'm affected because I'm in a flood zone. I pay for flood, ridiculous amount of money for flood insurance. And what they're doing to the property could really affect me as to what they're going to do to the road. They're going to pave it. And my other concern is that, okay, you give them, they're willing to sit here, and they're going to tell you, oh, we're going to do this, we're going to do that, and we're doing this now. But as soon as you issue that permit, it all goes out the window, and it's not going to be a concern, and maybe they're not going to answer the phone when you call them next time. And the other issue is that they bought this property in October of '23, and since then, they have not gotten approval for anything yet, and it's been business as usual. They've done conservation work. I looked out my back deck the other day, and they've got this little skid thing, and they're, like, doing stuff to the road. I know they've got, like pea stone down there that they're spreading. Like, they're doing stuff without a permit.
Ma'am.
So what's going to happen when you give them the permit? It's just they're going to do whatever they want. They're doing it now. Like, okay, maybe they're not doing stuff inside the building. Who's checking on that? Who's verifying what they're doing and what they've done so far is in compliance with anything? And that's my concern.
All right, Gary, hold on, before you go any further. Allow me, there's a chair. Ma'am, we've been addressing this issue for months. It is a variance that exists since the 1960s. this building is going to have something in it, regardless of whether we like that or not.
I understand that. I
Okay?
understand that.
It
that
doesn't seem
something
like you
has to
do,
go
though.
there.
Hold on, let me finish, because I'm the chair, and I'm speaking now. So, the building inspector has been in that site numerous times. Because they own the building, they have a right to improve that building. Just like if you bought your house, you have a right to improve that house. You can cut your lawn, you can mow your grass, you can snow blow, just like they can go in there and fix bathrooms and build things in anticipation of getting the permits. They have a right to improve their property just like anyone else. It's not subjected to business or commercial or residential. We've been trying to negotiate this for months, willingly trying to help out with the abutters. And again, I think you got to understand, if we stop this, they're going to go to court. They're going to continue to operate until the judge tells them yes or no, regardless. That's 2 or 3 more years, because that's just what Worcester whole courts are backed up to begin with. And then likely scenario is because we have a variance attached to this property from 50 to 60 years ago, that they will likely win in court. I cannot say that will definitely happen, but predictability is that will very likely happen, which means at that point, as Ms. Roach tried to point out earlier, is then they can do whatever they want when they want, because we will have no say whatsoever. We're here trying to negotiate in good faith with everyone to get the best case scenario for you as abutters. We're not here to work against you. So if we say no tonight, it continues. I hate to tell you that, but it will continue on. If we move along to the next month and we try to negotiate and continue along again, we're in better shape than we were. But again, I need people to understand, this is not something that we can just make go away for you. And I wish it was.
I understand it's a warehouse, and right, something has to be there. And I believe the last thing that was there was like a tire warehouse company. And I wouldn't have even known there was, really, it wasn't a nuisance. Like, they had just like a commercial type pickup truck, they'd go by with some tires in it or something, but it wasn't 18-wheelers. I mean, that's the thing. I mean, I get it, something's gonna be there, but, I mean, I've been in my house for 34 years, and I've hardly even noticed that warehouse, like whatever's been in there, honestly. And now, since the spring, it's just been tractor trailers all day, and I get it. I understand that something's going to go there, but I mean, don't we have a right to limit what's going to be there? I mean, going back 60 whatever years, I mean, doesn't the town have some right to say, no, this can't be. It's not this is not fit in a residential neighborhood. It just doesn't.
Had that variance not been issued back in the 1960s, we probably wouldn't even be having this conversation, quite frankly, ma'am. Because that building wouldn't even be there to begin with. You'd probably be looking out your window and seeing houses. But because something occurred long before us, we're stuck with it. And it's going to be stuck long after you and I are gone from this planet, unfortunately. It's going to last forever until it changes. But there's nothing we can really do about that right now. And I feel for you, and I apologize. I wish there was. And I see your frustration, and I feel it. But unfortunately, these are the consequences of past errors that we have to deal with.
I'm just concerned, like, what's going to happen when you issue that permit, then it's just going to be whatever they want to do, because they bought it over a year ago, and they've been doing whatever they want without any permits, so.
And again, that's what I explained to you. They have a right to improve their property.
Well, yeah, but, thank you.
Yes, sir?
Again, improving the property is one thing, but expanding the business is something else. So you can have 20 trucks today, and you might have 30 trucks tomorrow, but 30 trucks in is 30 trucks out, not 5 in and 1 out. And if you've ever been to a redemption center where they're crushing bottles in these little containers that you put a bottle in and it crushes it, that's noise. That's loud noise, and that's inside one little container. So by crushing bottles, especially bottles, by crushing bottles and breaking bottles, that is very loud. So if you haven't gone to a redemption center, you want to go in there and just listen for 3 minutes. So once this thing gets passed, it's going to be there forever. The other two fellows that were here, that 35 and 25 Rockland Road, you know, they said, we don't like it, but we're trying to compromise. Well, what's the compromise? Say no, and if you want to move someplace, but make it something else. You can't have noise and trucks in a neighborhood that's residential. And that's 18-wheelers trying to move in that driveway down around the creek. That's always wet. So, once you do it, that's it. Thank you.
All right,
I'd like to see a sound study.
again, that would be at the planning board, though. We can't ask for that here. Not for this. This is specifically for the zoning of this particular building. At the next stage, they can request that, but we can't request that particular step for this. This is whether or not this variance meets the purpose of this particular usage.
Mr.
I
Chairman,
didn't think it did the last time. It's something to do with industrial, I don't.
It matches pretty, Caleb made the same decision.
Hold on, we haven't given a chance to Ryan to speak here, and
And they started in there.
So I don't have the variance in front of me, but I do remember that the phrase used in the variance is light manufacturing, provided it's
Correct.
not a public nuisance, I believe. And light manufacturing is on page 20 of the zoning bylaws. And it's the process of converting raw, unfinished materials or products into articles or substances of a different character or for a different purpose. That fits pretty squarely with what they're doing. They're converting cans into aluminum, pretty much.
As long as it isn't a nuisance to the neighborhood. Okay.
That's the building and the process itself. You know, the trucking is kind of outside that, sort of privy on that. I mean, most of it is on the public roadway and on the driveway, so it's like, you know, like they said, that's why I feel if this goes before a judge, he's gonna look at this just matter-of-factly that this meets it, I have no jurisdiction, and see you later. Right now, you've got, you know, abutters working with the businesses. I don't think you can get a better, you know, a better handle on it than that, and that the planning board at their point can add conditions on that, hours and things such as that, and hopefully maybe even work with DPW, whatever, to see if there's any way to, you know, get the vegetation back, widen that, you know, it hasn't even been determined where the end of that roadway is gonna be, whether it's gonna be paved, and now there's still quite a bit of process that's ready to go on with that. And they've shown that whatever it is, they're gonna comply with it. They've been very good about anything that they've been served up, they have stepped up to the plate.
it sounds like we're right on the cusp of closing the public hearing. Before we do, if I could ask the applicant one final question. And forgive the hypothetical, but if we were, as a board, to vacate the previous decision, would the applicant be open to conditioning an approval with the conditions that you had enumerated earlier based on the agreement that you had come to
Yes.
with those topics
Yes.
specifically?
Yes.
So, thank you, sir. So I'm good for now, Mr. Chairman. I would take this into non-public hearing discussion at this point.
again, I just want to remind the board, too, that we don't have to make a decision tonight. We can sign our original decision. We don't have to make a decision tonight. We could continue this hearing for another month if you wanted to sit on it. There's a lot of other options. We don't have to make this decision this evening, just to be clear. All right, so I want everybody to understand that.
I have no more questions.
Okay. Ms. Roach?
No, I think it's time to close the public hearing, board discuss and figure out where we're gonna go.
Would you repeat what you had, what,
Any more questions?
no.
Okay,
Okay,
through the chair, of course.
okay. Do I have a motion to close the
Got my
public portion of the hearing?
Mr. Chairman, motion to close the public portion of the hearing?
Do I have a second?
Second.
All in favor?
Aye.
All right. Your thoughts, Mr. Maron?
The following, so, and forgive, I'll be very brief, but forgive the history. So, when this hearing first came before us, I remember opening my discussion with questions on why were they even here? Why was this necessary based on the use and the proposal for this? And as we went through that hearing, Mr. Chairman, I had went on record in recognizing that their variance allows them to operate that business at that location. And the change of what the previous business was in there, far historical, doesn't matter, right? So this is a new business, they're able to use this in the use that they're using it. But what I determined based on, and I leaned very heavily toward public comment, specifically on the public nuisance clause within how that variance was issued. Because it was clear to me that there was, a significant nuisance to the neighborhood. But that nuisance, as it's been pointed out tonight, comes from truck traffic. And two things I learned tonight: that truck traffic as a topic has been negotiated and discussed openly with the neighbors. And the second point is that the truck traffic is not what that variance, the truck portion of that business is not what's under debate for approval. What's under debate for approval is what they do inside that facility, which is not the primary root of the nuisance that I opposed the original permit for. So, in total, if we do the math, where I am with this, Mr. Chairman, succinctly, is that I am absolutely open to vacating the previous decision, allowing the applicant to go forward with the conditions that they've mapped out. Because what we're trying to do is we're trying to go after a condition of nuisance that has nothing to do with what we're permitting.
Correct.
And so that nuance is important, right? That's really important. So we're trying to control something that's really outside of the purview of what we're issuing a permit for, which, in view, respectfully, is not fair to this applicant.
At all.
And then I'll just be blunt and point out the obvious, which you've articulated, Mr. Chairman, is that the risk here is, just based on matter of fact, this variance goes before. What this applicant has afforded us is an opportunity to have a forward discussion. What they could have done is taken our decision and said, sign it, and then gone through a litigious process, which we would have likely failed. We would have cost the town money. They would be stuck with this. It has been pointed out tonight, in the end of that process, there would be very little that we could control. This gives us an opportunity with a willing applicant. So, in summary, for the board members to consider, I would be open to vacating our prior decision, reopening this with conditions, and moving it forward.
Okay, thank you. Mr. Cussy?
I have no comments, but the one comment I would have is, I just don't want to, anytime there's a threat that we're going to be sued, we're just going to, say okay.
No, right, I agree with that, but I just think this one seems pretty obvious.
We're not going to just rubber stamp things.
No, but that's absolutely fair, Mr. Cussy.
That's my concern.
That's fair.
So I'm good for that.
Okay. Ms. Roach?
I think Mr. Marin and I agree 100% for the first time and probably maybe ever.
Mr. Chairman, I'd like to amend a few of my earlier comments.
Yeah, I think some of the things that were suggested, I realize things can happen, and I think in an effort to do the best that we possibly can for the neighbors, I think we do have to take a hard line on the trucks. If there's traffic, if there's whatever, then guess what? They gotta figure it out. They gotta go to the site or wherever it is off-site. I know it's inconvenient. I know it's not a great solution, but I think we do have to take a hard line on some of the conditions to protect the neighbors the best we can. Respectfully, I was not here at the last meeting. I did not vote on the last hearing. I do think the board got it wrong last time. I do have a Mullins rule paperwork to submit to Adam, because I did watch the hearing. But I think we got it wrong the first time.
Okay, thank you. Mr. Chacolo, sir?
Nothing further.
Ryan?
Nothing from me.
Okay. And again, I think Mr. Marion pointed out a lot of very good things there, you know, talking about how, where we are in our purview and what we can do with this. I also like the idea of the conditioning of the permit. I also think that it would just be advantageous to us to make sure that if it steps onto the planning board, then we, you know, the zoning board can voice its concern of a traffic study and a noise study, and we can say, you know, we had serious discussion in our meeting about that, just to make sure that you were aware of it, even though it does not fit our purview, so they can address that concern as well. And again, I think, you know, this is one step in the process. They still have to go through conservation, all the other things along with it. And I think that it's in our best interest to move forward and let the other parts of the process play out. That's what I would suggest. As much as, again, I don't think this project is not palatable to anyone. I recognize that. It's frustrating. I recognize that as well. I wish that we could go back in time and erase these variances that exist in town that we have no control over. Unfortunately, we can't, and that's the one thing they always caution about giving a variance out, is because they are basically irreversible and unbreakable. All right, so that's why they're always concerned about handing those things out. So, you know, that's where we're at, I think. So, if there's no further discussion, I think what we have to do is set this up like this. So, A, are we willing to vacate our previous decision? Or are we gonna sign it? Or are we going to take this new information into consideration and make an approval and allow it to move forward into the next step in the process? So, I think I will start with, I'm gonna read it regardless to make sure that we're all on the same page, and then I'm gonna break it down into those sections. So the 6:10 PM applicant, Arbor Recycling Incorporated, requesting a special permit under section 8.2.2 of the Auburn zoning bylaw for a warehouse located at 47 and 49 Rockland Road, Auburn, Mass., map 17, parcel 177 and 224. Is there a motion to vacate our previous decision?
Mr. Chairman, I'd make a motion to vacate our previous decision on the applicant as stated.
Do I have a second?
I'll second.
All in favor?
Mr. Chairman, respectfully, I think a roll call vote
You're right.
would be prudent here.
Okay. Vice Chair Maron?
Approve.
Mr. Cussy?
I'm going to stick with denial.
Okay. Ms. Roach?
I'll approve.
Mr. Chacolo?
Prior to giving you my vote, your next step for an alternative, because that's going to affect my vote, okay, would be, question mark, you vacate that, where does that leave this?
If we vacate this, then we make a vote to decide whether or not we're going to accept the application and approve the permit under section 822 of the Auburn zoning bylaw for this particular parcel and section, and then determine, so are we going to allow the permit? We're going to vacate the existing decision that we have not signed, and are we going to move forward with another one?
The existing decision was to deny.
Correct.
This is not a change, a two-year change. This is
Well,
the same
We haven't signed
thing.
it yet. That was the whole point. They came before the board asking us not to sign because they were negotiating
That's right.
between the two parties.
But you've got a decision on it. You've got a decision.
Not until we sign.
There's nothing significantly that's changed. And you're bringing forward the same thing, and we're looking to vote on this. If you voted to approve, and I'm not saying whether I'm one way or the other yet, okay, but if you voted to approve, where would that leave us?
Will that leave us for what?
We voted once to deny, and now we're voting once to approve, if we do that.
The vote to deny is not official until we sign it. So right
Right.
now, there is no official decision on this.
I guarantee you they have legal standing because we voted on it.
Not until there's pen to
Until
paper.
it's signed. The appeal period starts after the decision is signed.
Yeah, they don't record the decision until after we sign it.
Correct. And there is an appeal period after we sign.
Yes, there
So
is.
if we do go forward today and approve, if that's what happens, and the abutters want to appeal, they do have an appeal period that would start after that decision is signed.
So
So
the
they still have it.
negotiations that they have gone through, if we approve, would mean nothing.
Well, if we approve, we could approve with
No,
conditions.
if we vote, so, all right.
If we approve this
If we
motion.
approve which one? The motion we currently have to
Yes.
deny?
Yeah.
That's
No, no.
correct.
Let me go back again. Mr. Barron's decision was, what was your decision?
My decision, Mr. Chacolo, was to vacate the previous vote.
That's the motion we have.
Correct.
Yes, sir.
That's all we're voting on right now. Do we want to vacate the previous motion?
Which, in my understanding, sets the clock back to, we've had a hearing, and we're waiting to, and we can then make a fresh vote, motion.
So the people that are opposing this, the abutters, okay, lose their position.
That is
They
certainly,
lose their position.
that is certainly a position to take.
That's the vote of the board, though. That's what we're here for as volunteers. That, we make that decision for them, just like it would be in front of a judge or anybody else. Yeah, that's, if we vote to vacate this, then they lose their ability to do that.
Mr. Chairman, respectfully, they don't lose their ability to appeal,
No, but they lose their voice on this particular matter, correct? Yeah, that's what happens every time we make a hearing decision.
All right. I'm going to deny.
So we have, I just want to make sure, you're in approval, because we got lost in the process here. You're in approval, you're a denial, you're in approval, you're a denial, and I'm an approval. So what does that leave us? 1, 2, 3 to 2. So is that a,
Yeah, we only need a majority on it.
correct? Yeah, okay, just want to make sure. Okay. So, and also, just for the record, Ryan is our alternate this evening, so he does not participate in these votes, and that's why I'm not ignoring him. He does a fantastic job, he's just not participating in this particular part of it. So we have a 3 to 2 vote to vacate the previous decision. All right, so the previous decision is vacated. Okay, so now, to the 6:10 PM applicant, Arbor Recycling, requesting a special permit under section 822 of the Auburn zoning bylaw for a warehouse located at 47 and 49 Rockland Road, Auburn, Mass, map 17, parcel 177, excuse me, and 224. So, do I have a motion to approve? With conditions and notations.
Mr. Chairman, I would make a motion to approve with conditions as articulated by the agreement between the applicant and the abutters that spoke this evening.
All right, but I think we need to articulate
need-
those things.
we-
We cannot ask for somebody to add them in later.
Oh, I agree.
as they
I need
add
his
it.
paper.
I wrote them down. I'll make the motion.
Okay, go ahead.
Draw your motion. Okay, so.
I'll withdraw the motion.
Okay, so I will make a motion to approve the 610 applicant, Arbor Recycling, requesting, sorry, I can't read, a special permit under section 8.2.2 of the Auburn zoning bylaw for a warehouse located at 47 and 49 Rockland Road, Auburn, Mass, map 17, parcels 177 and 224, with the conditions that the truck deliveries are limited from 9 AM to 5 PM. Hard stop, 9 to 5. That all glass or any material only be crushed or worked on inside the building. This is gonna be a little vague, but that the company make the best effort to work on the truck patterns and logistics. And those were the ones that were,
And then I think we would like to make special note to the planning board of the concern of having a traffic study and noise study.
yes.
at their purview, should they choose to approve.
Yes, I don't think we can condition for that, but we would hope that our fellow board
Correct, would take that under advisement.
into
I think,
consideration.
Due respect to them, I mean, however that is appropriate to approach them with that, I don't want to, suggest that we are compelling them in any way to do it. I just want to make sure that they know that it was discussed in our hearings. Okay.
Mr. Chairman, before
You may.
moving forward, I just want to clarify, Attorney Broder had said that there's kind of two different hours of operation, 7 to 6 for the company-owned trucks and 9 to 5 for the redemption contracted-out trucks. Are we conditioning 9 to 5 for both types of trucks? Was that what your motion was, Ms. Roach?
That's a great point, Ryan. In your opinion,
Yeah. let me get
was
out.
the 7 to 6 trucks also tractor-trailer trucks?
I think they were. They're company-owned tractor-trailer trucks, so the ones that go out throughout the region for the company, and they're the ones that they said if they get in at 6 o'clock, when the gates are closed, they'll go down to the Worcester facility and get in the next morning.
Yes. Then I am a 9 to 5 on a tractor-trailer truck, period. I don't care where it's coming from or where it's going. For me, I mean, you guys don't have to agree with that, but that's my position. For the neighbors, I think we have to.
So do we have a motion on, do I have a vote on Ms. Roach's, or a second, excuse me?
Second, yeah, we need a second.
Motion.
I'll second.
All right, so I have a second from Mr. Maron, Vice Chair. So let's do a roll call vote. Vice Chair Maron? Mr. Cussy?
I approve.
Approve or deny?
Yeah, this is to let the business go forward. I have to approve.
Thank you, and I will vote to approve. So with that said, I believe that we've covered everything appropriately here this evening. In terms of procedural, if I made any errors, I apologize, and I will work to correct those over the next few weeks before this paperwork is completed. But it has been approved. The previous decision has vacated, and you will move on to the next step. So good luck with everyone. Hope it goes well for you. Thank you very much for all of your time. Thank you very much for the abutters. I really do genuinely appreciate that. So do I have a motion to close the hearing?
Mr. Chairman, I'll make a motion to close the hearing.
Do I have a second?
Second.
All in favor?
Aye.
Aye. Any opposed? No. All right, so,
Mr. Chairman, as they exit, would it be inappropriate to ask Mr. Broder a question?
no, because the hearing is over and done now.
Okay, so this is just general, this is 501 talk at the bar.
Okay,
Okay.
but I am going to excuse myself to use the facility, and I'll be right back.
Okay, very good. Well, certainly. Ms. Broder, as we articulated the conditions in that, with respect to my colleagues that were copiously writing it down as I wasn't, did we leave anything out of your list?
Well, it's the distinction between the two trucks that's really going to be the problem at this point. 9 to 5 is the independent trucks, the redemption center people coming to the facility. 7 a.m. to 6 p.m., which is what we're running now, is the company trucks. So with the conditions that you articulated, a 9 to 5 trucks altogether is a pretty big problem operationally.
Oh, I thought I specified tractor-trailer trucks.
Yeah, well, the company-owned trucks are tractor-trailer trucks as well, or box trucks. Yeah, so they're both box and tractor-trailers. But the other conditions, I think so. The glass inside and, yeah, I think so.
It's restricted us, we're currently operating set in agreement with the neighbors for months now, 7 to 6 for our vehicles, no restrictions. We reduced the delivery period in negotiating with the neighbors for the redemption vehicles, which are also tractor trailer and box trucks. Those guys are now coming in the middle of the day, so that this way, per hour throughout the course of the day, it's smoothed out the number of trucks coming through. To restrict my tractor trailers into 9 to 5 is only gonna probably make it louder from 9 to 10. Now all of a sudden, I'm gonna have all my tractor trailers leaving at the same time.
But you won't get your routes done. Everybody will be off-site. It's kind of a mess. So we are sort of left with two choices if we're still having a, what did you call it, the 501 after work?
501 talk?
Yeah.
Yeah, it's what you do after hours.
Sort of just
at a
left with
bar.
two choices. One is take your special permit decision that you just granted and appeal it because the conditions are not palatable, or operate that way for a period of time and come back and ask you to amend those conditions at some point to go back to where we had hoped to be. So I'm not sure what we'll decide, but that's kind of where we're left, what we're left with.
Thank you for clarifying that. I appreciate it.
All right, so we need to move on with this hearing. I appreciate everyone. I understand the concerns. This is a very complicated situation, but we need to move on to the next one. So if you could vacate from the 610 so we can move on to the applicant for Perry Place, I would appreciate it.
Giving you some leeway. If you can't figure it out, then, if you can't figure it out, then fucking sue us. Go ahead.
Another late one.
All right, gentlemen, if we could vacate the room, please. I still have one more hearing to go into tonight. If we could continue that conversation someplace else? Thank you. Yeah, okay, thank you. Here you go.
The special permit was for the use.
Yeah, but it was weird because they had a, wait, what's this? Oh,
It doesn't really matter wherever you can sit wherever you like. I just need to get these gentlemen to head on out so we can continue with our hearing.
I think the table was just here from the holiday party.
Yeah, but if they, you absolutely can use it if they're more
Yeah,
comfortable.
you can
set-
use it.
To set your
I'm
stuff
gonna
up.
have to bring, I'm gonna start bringing us a magnifying glass.
No, that's not too bad.
I like the table.
It's either that or
Why
get,
did they all do it?
either that or get, you know, the things I use for woodworking, you know.
Okay. Do we need a 5-minute recess?
Said I
Or do
got
we
the
need to, can
call
we continue?
today. My hearing aids are ready.
I'm good with, Mr. Chacolo, 5-minute recess, or are you good?
I don't care.
Let's cross
All
it.
right,
Let's do it.
can I
Let's do
bring
it.
the room's attention back to center here, please, so we can continue? Thank you. Okay. Is somebody speaking out in the hallway again? We need to get some quiet signs out there or something. Okay,
It's crazy how that projects.
it's like a speaker.
It really is.
It's unbelievable.
He and I were like whispering and they
Yeah,
came
you
out
can
and
literally
they're like-
whisper and it
Yeah,
just
you can
it
hear you.
projects right over that
Wow, we were
wall.
talking really quiet.
All right, side conversations are complete. Can we move over to this one, please? Thank you. Applicant 16 Perry Place LLC requesting a comprehensive permit under Mass General Law 40B for a housing complex at 16 Perry Place, Auburn, Mass, map 18, parcel 14 and 15. Reminders, this is an open hearing. It is not a reopening. This is a continued from 11/21/24. So is the applicant present? I believe that we are focused, particularly this evening, on traffic issues, if we could, sir.
So with the, the traffic study has obviously been done. We did get the 16 Perry Place, James Venacasa, 16 Perry Place, 16 Perry LLC. We did get the traffic study. We did review back. We still have not gotten the review back from our engineer to give to yours. So that we're at a little bit of a stalemate tonight. There's no big update with that. We're still working on getting all the data. There was a lot of things that they're asking for recounts and everything. So he's been working on that. We're just not complete with that. So if we don't have as much on that tonight,
Oh, that's okay.
honestly.
Yeah.
So hopefully for the next meeting, we would have that review back. We did complete we got the review from Graves Engineering. We did change all the plans. We did resubmit to Graves Engineering, which we believe that we've addressed all of their issues. Most of the civil review was kind of minor edits and little details and whatnot to put on the plan. The larger stuff that we did have to make changes to the plans to, I just printed a 8.5 by 11, and we put the changes in red. Obviously, there's no difference from this plan than to the full set that has been submitted to the board. The only difference with this is we just put the changes in red. You know, coming into Perry Place, We added a sidewalk and a little retaining wall coming into the community, out to Perry. There was a sidewalk then continues in front of building number 1 in red, where you see that. Again, sidewalk going across there, and the sidewalk wrapping around. So that was one of the changes. We also changed some of the radiuses within the community, and pushed back the garages a little bit more to give a little bit more room for the swinging in. Those were the larger changes, the real changes that we did to the plan. Drainage, they reviewed and approved all of our drainage and everything, so I think the big stuff has been addressed. Again, if you go through our review letter and response letter to the town, it's all a lot of minor stuff. I'm not going to bore you with all those details.
Okay. So realistically, this is, again, you know, the continuation of what we've been talking about here. So I think I'm just going to go ahead and turn it right over if we have any abutters that want to make any comments, and then we can bring it to the board, right? Okay? Do we have any abutters that would like to comment? Yes, sir? If you're going to give us your name and address? I'm sorry, what?
Good evening, Chair, and Board. I've put together a little bit of packet for you that if you wouldn't mind, I'd like to
Sure,
pass it off for you.
Okay. Thank you.
Yes, sir.
Thank you. All right, so just while he's passing these out, I just want to, just for the record, what it is. It says here, 16 Perry Place Project Community Spokesperson Endorsement. This is the signed 1, 2, 3, 4, 5, 6, 7, 8, it looks like 9 Perry Place neighbors have signed this particular document, and we have a legal notice for Sunday, December 15, 2024, Town of Auburn, Board of Appeals, legal property owners, use, widening, or improvements of Perry Place. So what they have here is a discussion on the nature and purpose of the easement, a cession of private property rights, denial of permission of authorization, Massachusetts easement law, bright line rule, reservation of legal rights, and then we have an additional 1, 2, 3, 4, 10 signatures on that one. So it looks like 20 signatures, 19 to 20 signatures altogether. And then there's a legal summary of argument in Martha's Vineyard Land Bank case that, just to be aware that that's what Mr. Largess has produced for us this evening and entered into the record. Okay, go ahead, sir, I'm sorry. Go ahead.
Yes, Mr. Chair. So as you can see, we did determine by the applicants admit last week that we do own to the center of the road. So you can see that in your packet, none of the residents want the road in front of their properties that they own to the center of the road touched. They do not want to give the plaintiff any extra property to widen the road. And you have all the signatures and the names on that. They don't feel that somebody should be taking this to earn income off of their properties. That was one of them. And again, if you give me a little leeway with the 3 minutes, I am speaking for all of those residents. So the land packet I kind of gave you, we're in the discussion here of 2 different land parcels. Okay, the front land parcel is originally 16 Perry Place, which was the Irish Realty Trust made the right-of-way usage. So that would cover that plot. The plot behind that, which initially was Walsh Ave, that was separated back in the 60s when 290 went in to the Zinnemann family. And the Zinnemann sold it to Mr. Paradise. Mr. Paradise sold it to his niece.
that is still listed as Walsh Ave. So technically, it's landlocked, but if you look through that package, sir, in the bright line ruling of the applicants, that is going to put a burden on the access to the road. The access to the road and the burdens were for the 4 houses that were at the end of 16 Perry Place. There was 16 Perry Place, there was 29 Perry Place, there was 32 Perry Place, and 39 Perry Place. So that burden on them, on those residents, along with 1, 3, 5, 7, 9, I believe it's up to 13, and number 4 Perry Place, also number 11 Pearl Street. So this burden is going to be an overburden of that street. The street was not designed for that, and that's pretty much, I mean, we haven't seen any traffic studies. I would have to say that in order to get a good traffic study, I think you'd need to put one at Rockland Road, one at the end of Perry Street at Auburn Street, which is deemed the 4th most dangerous intersection in the town due to DOT and police department. That was right in the selectmen's meeting, and one on Pearl Street. So you can get an idea of which way the traffic flows and how many vehicles a day are going to come out onto those intersections. You know, according to the calculations of the applicant, and the fire chief did his multiplications, we're at 2,000 vehicles a day. And I don't think as a safety, you know, Perry Street and Auburn Street is going to be suitable for that amount of cars. The residents on Perry Place, going back a little bit, do not want to relinquish any of their property. They do not want it upgraded, bless you, they do not want it touched. I don't know how the applicant's going to get 24 feet out of this. Yes, granted, he's going to put a sidewalk in. One of the other issues the applicant came and said last week is he had a 30 to 40 foot frontage going into the property. 10 feet off of number 32's property leaves you maybe 18 feet, if you're lucky, knock on wood. I don't know how he's coming up unless he fills that swamp in, which is going to really burden everybody on the other end of the road, because it's going, can I have any place to overflow? It's going to be a horror show. I think I've pretty much touched everything that I need to touch. Does the board have any questions for me?
So before I continue to the board, though, do we have any other butters that want to speak? Okay, let's get through the butters first. Go ahead, please. If you just approach the lectern one at a time, give us your name and address.
Okay, my name's Thomas Donner, and I live at 29 Perry Place, and I want to address the traffic and the sidewalks. So it's my understanding that they want to build sidewalks on Perry Place, which is great, but they're leaving out Perry Street, and I'm going off, okay, now they're saying 2,000 cars going up and down the street. Perry Street, I think you guys gone on Perry Street, and you know how narrow it is, and my concern is we're getting pedestrians on Perry Street, kids riding bikes, families walking their dogs with their kids and all that on Perry Street, so now they're unprotected. So I think that needs to be addressed also, not just Perry Place, but Perry Street. So that's my concern.
Yes, sir?
Paul Dockery, 32 Perry Place. Again, like I said last meeting we had, it's a private main coming down that road. It's a private road. We're not willing to give up our properties for that. And not as saying sidewalks, what about lighting? There's no lighting on that street. There's one street light on that street. So are they addressing lighting also? You know, but there's so many issues with this project. It's not the place for it. You know, single-family house or a duplex, yeah, that's fine. But for 150-something, you know, and like they said, you know, it's a beautiful building, blah, 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 but it's not next to your house. It's not beautiful. So that's all I gotta say.
Anyone else?
Okay, I thought this was just on traffic, but lighting was addressed. So another thing I want to address is the power grid in that area. With four condos?
There's 3 buildings.
Okay, 3 buildings, whatever. How is that going to affect our area as far as the power? Has anybody done any studies on that or anything like that? Has that been addressed? Because I haven't heard it from the meetings that I've attended. So, again, that's it. That's all I have.
Okay, thank you.
I was trying to do the math.
Oh, I know. That's okay.
So I think we've heard the concerns that we've addressed, or at least heard earlier, where we're still concerned with traffic, we're still concerned with safety, which is really where our purview is on these particular projects. 40B is very difficult, but it is the areas that are being addressed is what we can try to negotiate through. So with that being said, Mr. Maron, to you, sir.
Thank you, Mr. Chairman. No specific questions for the applicant this evening, just a general process question. There are several requests on relief that are requested for this application. I'm just wondering when, in fact, we're going to start walking through that.
Relief in terms of what, sir? I'm sorry.
Forgive me, I'm taxed, and I'm trying to find the right language.
Excuse me, Mr. Chair, could I get a copy of the, what they're requesting or what they're asking for?
Oh, yeah, all these are, I can't give you this particular package tonight, but all of this is available public information. Anything they submit, you can have copies of.
Thank you, Mr. Chair.
Absolutely.
I could pick them up at a later date, next week, something?
I would assume if you want to call the Department of Special Services and tell them you want all this packet, yeah, absolutely, they'll be more than happy to give it.
Thank you, Mr. Chair.
I believe me, when I tell you I believe in full disclosure, I want all of this stuff out on the table. I want everybody to have a complete package to make sure we have all the informed decisions in front of us, so.
Yeah, it escapes me, Mr. Chairman. I had it in my office earlier today.
Okay.
Ms. Garabedian, did you have a,
I don't have it in front of me, I couldn't find it either.
but you know what I'm referring to?
The request for relief from the zoning bylaws,
Yes,
right?
yeah, the specific bylaw request for relief.
One of these documents I thought had it.
Waivers is what I'm looking for. It may be here, Mr. Chairman, but I'm just wondering when in fact, in a matter of process, yeah, I've got it here. December 11th correspondence that walks through several waivers that are being requested. I'm just wondering when we're going to take that business on line by line.
So, I think if you recall, last time, we agreed that we would kind of take these in smaller bites, and that we would try to provide each meeting with a focal point. So this one was, we were trying to address traffic issues. If you want to say those are what we can talk about at the next one, we can certainly do that.
Okay. Yeah, thank you, Mr. Chairman. You well read my mind. Is it just trying to move the business along with what we have in front of us?
Yeah.
I'd like to get to the waivers. I did have an opportunity to take a look at some of these this afternoon, so I think at a future meeting, we should make that.
Well, I mean, we are certainly, again, we had decided to discuss traffic issues this evening, but it appears to me, we can get through the rest of the board here, that we may not be able to, so we could probably start talking about some of those tonight. if I
Yep,
get rid of
yep,
this.
not pushing forward for it, Mr. Chairman, but yeah, but make that a priority focus for a future meeting.
Mr. Cussy?
Yeah, I was just interested in traffic study. That's what I was planning on, but we don't have it, so.
Ms. Roach?
Yeah, I do have a couple questions for the applicant. I guess first, I'd just like to maybe address Mr. Largis's comments. I think we as a board agree that access is an issue. That is out to town council, and we are waiting for replies. So I don't think that's something that we want to get into tonight without town council's weigh-in. But I raised that at the last meeting, and I still firmly believe that access is an issue. But I don't think we have any further information to talk about that tonight. But on the traffic study, there does seem to be a lot of comments in here about additional data. So I think Mr. Benincasa led to this in the beginning. Is what your position is that you, these comments, as many of them where they say that they think additional traffic data should be taken, this was done in 2022, they want more updated numbers. Is that what you're alluding to, that data is currently being collected?
Yes, James Benincasa. So we had a call with our traffic engineer and then the peer review engineer, and they did raise, there was a couple intersections that they asked for additional data from, so that's what they're working on. We just don't have it back yet, but there was a couple intersections. I forget the exact names off the top of my head, but I'm assuming it's probably the same ones that Mr. Largess is referring to.
And then can you speak to the parking situation? There's also a couple comments in this about the number of spots not being sufficient as well as the size of the spots, them being 18 feet long as opposed to 20 feet, which is what we require in town. Is there any plans to modify the parking as it stands?
So I believe with the traffic engineer too, he did agree with the ratio that we used. I don't remember exactly what it was. Do you remember, Steve?
Yeah, so it looks like it's on page, hold on, the page at the top. It's on page 7, and it's comment 15. It does say that you guys account for about 1.6 spaces per unit, and the town bylaw states 2 per unit is required. And then, hold on, let me just keep going on here. If you could, can you just remind me, I know we talked about this last time, there's some that are 3-bedroom.
Steve Benincasa, I'm just rambling through a number of items. Stop and take one at a time.
Sure, yeah, so I guess in the parking, the reason I want to talk about it is just in relation to how many units you have. And I mean, how many 2 bedrooms, how many 3 bedrooms? I know you guys have 1.6 spaces per unit. If you had all 1 bedrooms, fine, but what's the breakdown of the units that are going to be there? Do you know that?
So I believe that the town bylaw was 1.5, unless I'm mistaken.
Yeah.
We're 1.6.
The town changed to the chair, the town changed the bylaw from 2 to 1.5 in May.
Okay.
That's a recent change.
Okay, so the traffic study is incorrect when it says that the town requires
corrected
2.
the VHB.
You fixed it, okay,
Yes.
okay.
Good catch, though.
We do have other communities that are built and operating, and we've found that the 1.6 was actually the number. We've tried to get closer to 1.5, but the 1.6 to 1.5 does work. Anything under that in this, in this area hasn't been working. Obviously, parking is a very big thing for us because you're not going to rent from us if you're not going to be able to park there, right? So obviously, it's a very large investment that we're going to be, putting over here, and we need to make sure that we can rent these units. And so parking is very important to us, but it's also a balance because we don't want to have a sea of asphalt. It's kind of the most unattractive part of the community is the asphalt. So we really try and always balance that. 1.6 is what we've seen has worked in the past, what we felt comfortable with, but obviously open to.
Yeah, and I just honestly asked the question because the report said that it wasn't in compliance with
Yep,
our
I get it.
bylaw. So if it is, then I withdraw the question, I guess. I just wanted some clarification on that.
Yep, I get it.
Yeah, I think that's it for now.
Mr. Chacolo, sir, to you?
Thank you, Mr. Chairman. Have we heard from the Conservation Commission as of this meeting?
Not that I'm aware of.
So we haven't filed with Conservation yet. We did file with Conservation probably 4 years ago. So when we initially purchased the property and we got the wetland line locked in, we'd established what the wetland line was. So we typically, on the communities, we haven't been going to Conservation until we know, basically any changes. Again, even with the changes that we moved some lines and got a little closer, put a wall. So we want to just make sure that we're bringing them the latest plan. Typically, once we know that the layout is what, we believe will be approved, then we typically file with Conservation. Again, the wetland line has been locked in the past, so we know what we're working with and obviously what we have to stay away from. So, what we're showing you is what we believe would be approved, but we have not filed with Conservation quite yet. But there was an order of conditions that was placed on the property and actually still is on there. We never closed that out.
So at this point right now, what do we need from the Conservation?
We don't need anything from Conservation right now. We're here to discuss traffic, and then what we're going to talk about at the next meeting.
Okay.
That's pretty much,
I'll hold
because we
off.
were just trying to break it down into smaller bites so people could
All right.
kind of come prepared.
You're only going to talk about traffic.
Well, not necessarily. Michael Maron here, Vice Chair Maron, had some concerns. If we got through traffic, then we were going to kind of set up an address for the next meeting.
All right. I'm okay.
Okay. So I don't think we can really discuss much with more about traffic this evening than if we don't really have the results of the traffic studies and we have some continuations of those with more data. So I think what we should probably do is prepare for the next hearing.
Could I just make 2 comments?
Oh, yeah, I'm sorry. I apologize. Go right ahead. I apologize.
So first, I just want to address Ms. Roach's comments earlier about the street. I know she said, and it's still at town council. I looked into it a little bit today, though, and there was a case that was actually pretty similar to this in the land court where the zoning board conditioned the site plan on getting an easement over the private way. So we could do that, and it's been recognized by the land court and affirmed by the Mass Appeals Court. That was in Lane v. Zelinski. And then I did just want to ask Mr. Largess a quick question.
Before you do.
Yep.
I apologize.
Yeah.
Can you go over that last point just a little bit slower?
Yeah, I'm sorry. So we've discussed the problem with the private way. And one of the things that another town has done is where there's a private way, they've conditioned, the zoning board has conditioned its approval on the applicant being able to prove they have an easement over the road itself to use the road and also for the utilities. The Massachusetts Land Court and Appeals Court both did recognize that there was an easement. I believe it was an easement by prescription, by necessity, since it was a landlocked parcel. But it was just a suggestion.
In favor of the applicant?
Yes. So both the courts found in favor of the applicant. The owners of the private way, similar to here, were saying they didn't have access to the private way, partly because this 40B in this case was a weird one where it was right actually on a town line, and the private road went from one town, I forget the town, and the project was in the second town. So the court ended up finding that there was an easement over the right-of-way.
Who granted the easement?
It was by prescription, I believe, is the court's argument. So because it was a landlocked parcel, the court said you have an easement to access the road. And also because they were abutting the private way, they own halfway to the road, and part of the ownership is you also have an easement. I believe in this one specifically, the deeds reference that there was an easement over everyone else's part of the private road. But even without that, the court found prescription.
Okay, so the court essentially issued the easement?
I believe so.
To the applicant, and it was in fact a 40B applicant?
It was, yep.
All right, thank you for that clarification, I appreciate it. When you guys get into that lawyer jive, I try to read the tea leaves. So I just wanted to pull that out. All right, thank you very much.
Excuse me, Mr. Chair. We're not denying the easement. we understand it's his property, has the right to use it. But if you look in that packet, there is a such thing as overusage and burden. What the residents are saying is they're not going to relinquish any of their property to widen the road, and they do not want the road in front of their house altered. So we understand there is an easement. Yes, the easement is for number 16 Perry Place. It's not for the second partial. The second partial was not part of Perry Place, so the burden of usage is going to be put on the residents, and we don't want it. And just to get away from this for one moment, I want to make it clear, the gentleman is talking about putting, bless you, the gentleman is talking about building on this property. My family has had animals there since 1958. In the spring, there are smells. There are noises. There is farm equipment being used. If there's a storm, we're out there fixing fences because I don't want to chase cows, and I've been there, done that. Okay, so there is going to be noise. There is going to be smells. There's going to be cows mooing. There's going to be chickens clucking. When the humidity comes in the springtime and the manure starts decaying, there are smells. There's no way around it. And I don't want this gentleman just plopping in the neighborhood and going, he's got to go, that smells. He's got to go, the cows are mooing. I've been there since I was born in 68. My father, my grandmother before me. It's, the builder needs to be aware of this, and I want to know how I could get protected from this board, on the zoning board. Okay? It's like somebody moving in next to you and saying, tough shit, I'm going to do this, 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 and this, and you have no rights. It's just not fair to, and I'm speaking just for myself. I mean, Mr. Dackery, Mr. Downer, we've been there. Mr. Downer is also third generation, probably fourth. I don't know what his ancestry is gone. And I'm third, possibly fourth. And our rights, we're concerned. We really are. So I wasn't trying to get away from the road at all, but I just wanted to bring that up and point that out to you. My apologies I didn't know when else I could say that.
That's okay.
So as far, we know he has the right of way, we know he has the usage. The usage is for the one lot. He did come to the town years ago, and it was just to see what he could get away with by saying, hey, we'll put in a brain rehab house. We're gonna see. And I questioned one of the boards, conservation. I says, well, if this is all he's doing, why is there a driveway over here? Oh, no, we're not here for that driveway. We already knew ahead of time what his plans were. He was opening up the door to see what he could get out of the town. And then for them to say, to make negotiations with the Board of Selectmen, saying, hey, we'll give the town $100,000 for your fireworks over 5 years when we're fully rented. That's all well and fantastic, but what about all the residents on the street? We're just gonna stick it to them? That's a lot of traffic on those small roads. Perry, Mr. Downer had brought up Perry Street. Perry Street, there's sometimes when the cars are parked on the side of the road and the kids are out there riding their bicycles. It's great. We need the housing. We do 100% agree with that. It's not the right place. The fire department said that. The police department said that. It's not the right place. Do you have any other questions for me, board, through the chair?
Mr.
No,
Chair,
go right ahead.
if I may. So I just wanted to check with you. Are the residents prepared to defend this document just because, from my reading of it, it could cause litigation between you and them. You are asserting that there's no change in the nature or scope of the easement, and they could argue easily in front of a court that because it's a landlocked parcel, there's easement by prescription. I'm not saying who will win, I'm just saying there is an argument there that they could try to enforce in court against the private property interest. It's separate from the board's.
Well, the board has the right to deny it.
And then they go to housing.
Well, they can go to housing. That's up to the board. The board can, the state gave you a packet, sent back a packet. Now, I'm sure that the board members have it. It was sent back after his application, and he has to cover all of the things that the state said. If he doesn't cover all of those, then you can deny it. So the main thing is the traffic. If he can't widen the road, the police chief said it ain't good. The gentleman said he talked about putting the garages back further. What, right on my cow pasture? What, am I going to be able to house my cows in these garages or store hay in them? I mean, how close are we talking about here? Then one of the other things was, is getting back to the traffic, he wanted to do public park, public walking. Well, again, that's just more burden of other people coming down through the neighborhood. It's an overburden usage on the road. So his 2,000 cars could possibly even be more if he does, oh, hey, I got a public park, come down here and, walk through the woods, get bit by mosquitoes. Get chased by a coyote, whatever, come on down. It's, the overusage of the road and the amount of traffic is insane.
Okay, so I think we've made enough progress in terms of, we recognize that the concerns of the abutters and the neighbors over there is traffic concerns. To repeat those things over and over again doesn't make it any less or more of a concern. So the board can take note of the traffic concerns. The abutters believe that it is an overburden of the road. There was also, I believe, some ownership of the road brought up that we are trying to clarify with the town council. I want to make sure I'm saying that correct, Ms. Roach? Is that the way we're saying that?
I think it's the overburdening that we're addressing with town council. There's no doubt they have ownership in them.
Okay, so the overburdening is what we're addressing then? So those are the things that we're talking about there. So I think for the next hearing then, since we are still waiting for results of all those modifications of the traffic studies, go ahead.
I'd just like to ask a question to Adam, if I could. Has there been any progress on a 40B consultant being hired?
To the chair, we have a preliminary meeting with somebody from Mass Housing in 2 weeks,
In 2 weeks?
January 2nd.
So I also want to make sure that Ms. Roach brought that up, is that we had a meeting last week. And to be fair and be honest, in the interest of full disclosure, there was only 2 of us present because the 3 would make that illegal. So, and it was informational meeting, excuse me. So, the concerns that were brought up in that meeting is what we're talking about here this evening, in terms of the traffic studies, in terms of the overburdening of the road, all of those things. And, we need to seek clarification on those before we can move forward, because we're not gonna, as chair, I'm not gonna allow any other stones to go on unturned, so to speak. I wanna make sure that we understand everything that goes on in this project before we even discuss final approval. The other thing you gotta understand is we are at a 6-month window with this, and we started in October. So that puts us in April for a decision and time frame, unless the applicant agrees to an extension if we're making progress, let's say. So that does put us under a time crunch. There is also a question on whether or not, what was the other thing we discussed? I just want to make sure that we just covered it all.
I I think traffic and overburdening were the
Right,
biggest
traffic
things.
overburdening, and then
just,
the issue of the private road in terms of them upgrading the road. So in other words, the abutters have the road, the abutters, it's a private road. So if these people come in and they develop this road, ultimately what it seems as though, and what we can see now, but we don't know for sure, is it appears as though the abutters still end up owning that road. So is that burden on the abutters because it's still considered a private way? So we need to sort that out as well. That's pretty complicated and could be a legal snare. So that's one of the things we're trying to figure out as well. With that being said, so we know that we're working on these things, and Mr. Maron brought up some other ones. So I'm gonna turn it over to him. What would we probably like to discuss at the next meeting, I think was where we should be. We can bring the results back if we have them from the attorney that we, brought the questions up to, and we can address those. But in the meantime, what should we be discussing at the next one? I think Mr. Maron brought up some concerns.
Mr. Chairman, I would just recognize the waiver list, and that we should start navigating through each individual waiver and take those topics on. But before we did that, just as a caveat, that if in fact a traffic study came back between now and the next meeting, then I would reserve, given anything that we were intending to discuss on that topic, that we put that in front of this.
Sure. Yeah, I think we should try to close the chapter of one thing before we open the next. So if we can do that, that's great. If we can't, then we should have a plan B to prepare to move forward on some other items.
Yeah, and said Plan B, I would propose that we go through that waiver list and see if we can make comment and any headway in that business.
Does that sound agreeable to the other members of the board, would you say?
so.
Yes? Okay.
Mr. Chair,
That's what I was gonna say. So the abutters next?
the traffic study, I highly would recommend Rockland Road at Auburn, Perry at Auburn, and Pearl Street at Rockland Road, just so you can get an idea of the traffic flow of what we're looking at.
So what I did learn is that even though we could request, pick a street, whatever it might be, unfortunately, the planners that look at these projects decide which streets would get studied. We don't have the authority to ask them if can you check this street or check that street? They look at it and they see it as a point of view of perimeter around that area, and they only check those intersections. Because I actually mentioned about 290, and they said it doesn't even.
Correct.
I had said, 290, we're backing up casually from the Mass Pike to Holy Cross regularly now, and they said that doesn't even, it's not even a consideration in a traffic study, believe it or not.
Well, the reason I said those three is you got cars that come right off that 290, look to the left, and the crossing guard, school crossing guard's been nailed twice, because they don't
disagree.
look.
I understand, yeah, all these points are valid.
Absolutely.
And again, we're waiting for the professional opinions on that before we make any decisions. Again, this is why I'm just trying to keep this focused and moving in some sort of direction. I don't know if necessarily it's forward, sideways, reverse, but try to keep it moving somewhere.
Bless you.
So, go ahead, ma'am.
Just if I could, on the traffic study, those are the intersections that are being addressed. Rockland Road, Highland Street, when you come out of Perry Street, and then the intersection at the actual light where if you come off the highway and you go straight across one way,
Fine.
that light. So those seem to be the four, like Mr. Tatro said, we don't get a say in that. That is left to the experts, but those are the four intersections that are mentioned
okay.
in the traffic study. Those are I'm sure you could get a copy of this at the town hall. There's yellow dots at those intersections on the traffic study itself, and those are some of the spots where they recommended that new traffic counts be done, and that is what's being done now. So hopefully we'll have that information at the next meeting.
Through the chair, what department would I get those traffic studies at? In the town hall?
I think, yeah, most of them are probably posted is this online, Adam? Are these documents shared online?
Okay,
They're
so,
online.
yeah, they're all online on the Auburn Guide?
Yeah.
Okay.
Yeah.
Or you can get them upstairs.
Yeah, it'd take me about 4 hours to try and find that online. I'm not that great with a computer.
I'm sure we can, I can request, if we could, just notify them. Can we make a hard copy available for Mr. Largess so he can review those things?
That would be more than grateful, thank you.
We can do that. Okay, if we don't really have anything else to continue on this evening, then I think we've made our points and we can schedule for next month probably, right?
Well, Mr. Chair, I just want to wish you all a happy holiday and thank you
as
for
well.
your
Thank
time
you.
and hearing us. Thank
Okay,
you.
So we know what we're focused on for the next one. I'd like to continue this hearing until the next meeting, which will be January 16th of 2025. Scary to think we're here, but thank you very much all for coming. And we will continue this until 1/16/25. All right, other business. Do we have any discussions, modifications? We do not, but we have decisions. We have 11 Grove Street and 25 Vinyl Street. Do I have a motion to accept those decisions as submitted and written?
Mr. Chairman, I'll make a motion to accept 11 Grove Street, 25 Vinyl Street decisions as written.
Do I have a second?
I'll second.
All in favor?
Aye.
Any opposed? Hearing none, seeing none. We have the minutes from 2/15/24, 5/16/24, 6/20/24, and 11/21/24. I just want to remind everybody, if they're still with us and watching, these minutes are being brought back up to speed because we were lacking somebody to do them. So we appreciate Mr. Fallon's hard work here, getting us out of the hole.
It was not just myself, it was Tim Pratt and Danielle, I believe, that did most of them.
Wow.
I did the last ones, yeah, that's going back.
Yeah.
These last ones were from February, and that's tough to go back and watch the footage.
It is.
I struggled just to do the 21st.
You must have a lot of popcorn. I will have to sit there and bags of microwave popcorn or something. So thank you very much for doing all that due diligence. We do appreciate it. I think that's it. So we have all of those. So, for the minutes, do I have a motion? I just want to make sure I said that. Do I have a motion to approve those minutes as I
Mr.
stated?
Chairman, I'll make a motion to approve the 2/15/24 and 11/21/24 minutes as written.
Thank you. Do I have a second?
I'll second.
All in favor?
Aye.
So we have no new business unforeseen by the chair, and we have an adjournment. So do I have a make a motion to adjourn?
Mr. Chairman, motion to adjourn?
Do I have a second?
Second.
All in favor?
Aye.
Aye. Any opposed? Didn't think so. Thank you.